What is that? Keep going when you come to the floor.
You haven't screwed up.
The committee will come to order. Judge Scalia, if you'll come around, please.
Come forward.
If you'll hold up your hand and be sworn, will the testimony you give in this hearing be the truth, the whole truth, and nothing but the truth? So help you God.
It will.
Have a seat. Would you like to introduce your family? You've got a lot of children there, and they may want to...
I would, Senator. They've taken a lot of trouble to get dressed up and come downtown. I think the little ones would probably want to leave after the first recess, but I did want to give them their moment in the limelight here, if I can remember all the names.
We'd like for those present to see them all. You have 9 children. I believe you have 8 of them here, don't you?
I think all 9 are here, Senator. I think we have a full committee. My wife, Maureen, is at the right in the front row. Next to her is Meg. Her real name is Margaret, but she said I should introduce her as Meg because when she's called Margaret, she's usually in trouble. Catherine, Christopher, Matthew, and in the next row from the other end, Mary, Anne, my oldest, Eugene, John, Paul, and that's it.
You have a good memory.
But don't try me on the ages, Senator. I'd also like to introduce, Senator, behind me, my law clerk, Patrick Schiltz, who's helped me in getting together the materials I'll probably need for this hearing.
Judge, do you care to say anything before we begin questioning? Do you have an opening statement you'd like to make?
No, I don't, Senator, except to express my honor at being nominated by the President and the fact that I'm happy to be here and look forward to answering the committee's questions.
Now, I believe Senator Biden suggested we have 20 minutes for the opening round until we get around. Then if we have a second round, it'd be 10 minutes from then on. Same way we did in the relinquished hearing. Senator Grassley, did you ever make an opening statement? Sir? Thank you. Judge Scalia, there are some very obvious differences in the roles of a Circuit Court of Appeals judge and an Associate Justice of the Supreme Court. The most glaring difference, I suppose, is that the Supreme Court has the final word on what the law is. It is the final ruling in the appeals ladder and can be overruled on constitutional interpretations only by a later Supreme Court decision or by constitutional amendment. What do you view as other major differences in the role of a Circuit Court judge and an Associate Justice?
Well, I think you've correctly identified the major one, that there's no one to correct your mistakes when you're up there, except the constitutional amendment process. In a way, there's a lesser body of law to look to as a circuit judge. I accept as precedent not just the opinions of the Supreme Court, of course, but the earlier opinions of my own circuit, and accept as very persuasive the opinions of other circuits. So it's a much more vast body of law that I have to consult in order to make my decisions. At the Supreme Court level, the most persuasive precedent is just Supreme Court precedent, although to some extent lower court opinions are looked to, but it's not nearly as important. I think you put your finger on what the main difference is, and that is that at the circuit court level, the opinions of the Supreme Court are the last word, and we follow them unwaveringly. At the Supreme Court, that is not quite the situation. The Supreme Court is bound to its earlier decisions by the doctrine of stare decisis, in which I strongly believe. Other than that, I suppose it's more difficult to be sitting in a panel of 9 judges all the time. On my circuit court, we now have 11, and when we sit in bank, it's a much more ponderous group to bring to a consensus than is a panel of 3, which is the normal panel. I expect that would be quite a difference.
Judge Scalia, as we rapidly approach the 200th anniversary of the Constitution of the United States, many Americans have begun to express their views about the reasons for the amazing endurance of that great document. Would you please share with the committee any views you may have regarding the success of the Constitution and its accomplishment of being the oldest existing Constitution in the world today?
I'd be happy to. I think a lot of Americans don't realize what a
And I don't have to go into the whole history of it. Just
I won't do it. I won't do it. I think most of the questions today will probably be about that provision of the Constitution that's called the Bill of Rights, which is a very important part of it, of course. But if you had to put your finger on what's made our Constitution so enduring, I think it's the original document before the amendments were added, because the amendments by themselves don't do anything. The Russian Constitution probably has better, or at least as good, guarantees of personal freedom as our document does. What makes it work, what assures that those words are just not hollow promises, is the structure of government that the original Constitution established, the checks and balances among the 3 branches in particular, so that no one of them is able to run roughshod over the liberties of the people as those liberties are described in the Bill of Rights. If I had to put my finger on what it was that's made the difference, that's it.
Judge Scalia, under the Constitution, certain functions are reserved to the federal government and others to the states, or rather they've been delegated to the federal government and others reserved to the states. Would you describe in a general way your view of the proper relationship between federal and state law?
The proper relationship, of course, is that federal law is supreme. If the federal government acts in a field over which it has authority, state law has to step back. When that should happen, of course, is most often a question of prudence, and that means that it's most often a question for this body to decide when it wishes to displace state law and when not. When it does so, that's the end of the matter.
Judge Scalia, since the announcement of your nomination to be an Associate Justice of the Supreme Court, you have been criticized by some for decisions you have rendered regarding the First Amendment and libel. Would you please give the committee your view as to why your interpretation of the First Amendment with regard to libel led to this criticism?
Well, I have to say it must have been misunderstanding, Senator. I don't know of anything in my opinions or my writings that would display anything other than a high regard and desire to implement to the utmost the requirements of the First Amendment. As a matter of fact, Senator Moynihan mentioned this morning, I'm the first academic to be nominated to the court since Frankfurter. I've spent my life in the field that the First Amendment is most designed to protect. In addition to having been a scholar and a writer as a scholar, I think I'm one of the few Supreme Court nominees that's been the editor of a magazine. So why anyone would think that I, if anything, if I were to have a skewed view of the First Amendment, Senator, it would be in just the opposite direction.
Judge Scalia, the Supreme Court's decision in Marbury versus Madison is viewed as the basis of the Supreme Court's authority to interpret the Constitution and issue decisions which are binding on both the executive and legislative branches. Do you agree that Marbury requires the President and the Congress to always adhere to the Court's interpretation of the Constitution?
Well, Marbury is, of course, one of the great pillars of American law. It's the beginning of the Supreme Court as the interpreter of the Constitution. I hesitate to answer, and indeed think I shouldn't answer, the precise question you ask. Do I agree that Marbury versus Madison means that in no instance can the either of the other branches call into question the action of the Supreme Court? As I say, Marbury versus Madison is one of the pillars of the Constitution. To the extent that you think a nominee would be so foolish or so extreme as to kick over one of the pillars of the Constitution, I suppose you shouldn't confirm him. But I don't think I should answer questions regarding any specific Supreme Court opinion, even one as fundamental as Marbury versus Madison. If you could conclude from anything I've written or anything I've said that I would ignore Marbury versus Madison, I ought to be in trouble without your asking me specifically my views of Marbury versus Madison.
Yeah. Judge Scalia, 20 years have passed since the Miranda versus Arizona decision, which defined the parameters of police conduct for interrogating suspects in custody. Since this decision, the Supreme Court has limited the scope of Miranda violations in some cases. Do you feel that the efforts and comments of top law enforcement officers throughout the country have had any effect on the court's views? And what is your general view concerning the warnings this decision requires? Now, I want to make this statement. Any question is asked about decisions of the court, if you prefer not to answer them, if you say so.
No, I don't think, I didn't take that
anything that
question
may
either.
come before the court, I don't want you to feel obligated to answer.
As to the second part, Senator, what do I think of those warnings? I'm happy to answer it as a policy matter, assuming the question is not, what do I think as to the extent to which those warnings in one circumstance or another are required by the Constitution. As a policy matter, I think, as far as I know, everybody thinks it's a good idea to warn a suspect of his rights as soon as is practicable. I don't know anyone that thinks it should be otherwise. As soon as the suspect is brought within the control of the police, he should have knowledge of what his rights are as a policy matter. The other part of your question, if I recall, was do I think the Supreme Court has been influenced by the views of police officers and law enforcement officials? I suppose. I don't think the Supreme Court lives in a vacuum. It reads the newspapers. I suppose it's influenced by the reaction of the society to its decisions. At least I hope it is. I think it should be. One would not know whether one's decisions are doing good or bad unless one consulted the effect of them.
Judge Scalia, in 1972, the Supreme Court in Furman versus Georgia struck down the death penalty provisions in federal and state law on the basis that under the statutes the death penalty could be imposed in an arbitrary and capricious manner. In 1976, the Supreme Court, in a series of cases beginning with Gregg versus Georgia, held that the death penalty was constitutional when imposed under certain procedures and criteria. In the years subsequent to these decisions, the Supreme Court has reviewed many challenges to death penalty statutes. Do you feel the Supreme Court has now provided sufficient guidance in this area?
Whether it's provided sufficient guidance, I'm not sure I have the data that I'd need in order to answer that question. It's always a difficult problem. One of the hardest problems, I think, for an appellate judge is how broadly one wants to write an opinion. Certainly providing guidance is one of the purposes of an appellate opinion. So you can write an opinion very broadly, which will answer all the questions for the next 50 years, or you could write it very narrowly and just answer this particular case and let the next one come up when it does. It's a hard call as to how far you go in one direction or another. I really don't know whether the Supreme Court has been as informative as it could be or should be. I think I have to say, not having been there, I'm sure they did what they thought was the best.
Judge Scalia, there are approximately 1,300 inmates under death sentences across this country. Many have been on death row now for several years as a result of the endless appeals process. Would you favor some limitation on the extensive number of post-trial appeals that allow inmates under death sentences to avoid execution for years after commission of their crimes?
Well, Senator, nobody likes frivolous appeals, I suppose, in any matter, criminal or civil. But to the extent that your question is asking about legislation, I shouldn't have a view about it. And to the extent it's asking about whether the Supreme Court ought to change its view of what the law requires to provide fewer appeals, I ultimately will have to have an opinion about it, but shouldn't set it forth here.
Judge Scalia, in the last several decades, we have seen a steady increase in the number of regulatory agencies which decide a variety of administrative cases. I realize that the scope of judicial review of these administrative cases vary from statute to statute. However, as a general rule, do you believe that there is adequate opportunity today for the appeal of administrative decisions to the federal courts, and do you believe that the standard of review for such appeals is appropriate? Again, I remind you, anything you feel that you should not answer, any matter you may feel will come before the court.
No, I don't think that will. I mean, appropriate, I assume you're saying appropriate. You know, Congress can alter the standard of review considerably. I'm not aware of any great dissatisfaction in the administrative law community, and I think I'm fairly familiar with that community, having been a denizen of it for a number of years. I don't know that there's any great dissatisfaction with the general scope of review of administrative action that now exists, which is essentially an arbitrary or capricious standard. The fine call is for the agency, and the courts look it over to see that it hasn't been so unreasonable as to be arbitrary or capricious. As far as I know, it seems to have worked pretty well. As to whether all review, whether there is review in enough instances and there should be review in more cases or in fewer cases, that's really a call for the Congress, on which I don't have any particular special views.
Judge Scalia, concern has been expressed with respect to the bureaucracy of the federal courts, the increase in clerks and support staff, and the supposed insulation of judges from personal decision-making. At the same time, the workload, the increase in complicated cases which raise technical scientific issues and other highly specialized disciplinary matters, suggests that judges and justices need more and more specialized assistance. Do you think that in addition to law clerks, the Supreme Court needs to appoint clerks or assistants with particular scientific or professional expertise, or is the solution to take certain issues involving science and other abstruse areas out of the courts altogether? Or is there some other solution?
No, I think you have them there, Senator. I personally, and I guess this is, you might get as, no, I don't think you'd get as many answers as you asked judges. Personally, I would not want a scientific expert on my staff. Institutions tend to do what you give them the capability to do. And if you give courts scientifically expert staff, they are going to become bodies that inquire into the scientific rights and wrongs of particular decisions. And simply the way our system is set up, those scientific judgments have been left to the Congress to make when it passes legislation, and to the executive to make, and to an even greater degree, by delegation from the Congress. As I said earlier, with reference to your question on the standard of review, all the courts are there for is to see whether the agency has followed the proper procedures, which is critically important, and whether in the final judgment that the agency reaches, the agency has been within the bounds of reason. I think I can tell without a scientific expert just on the basis of the record in the case, whether it's within the bounds of reason. And I personally would not want the courts to go any further than that, or you're just duplicating the work of administrative agencies.
Judge Scalia, do you believe that the court has given sufficient consideration to relevant economic analysis in evaluating the effects of restraints of trade? And are you satisfied with the guidance that the court has provided on the proper role of economic analysis in antitrust law?
Senator, antitrust law has never been one of my fields. Indeed, in law school, I never understood it. I later found out in reading the writings of those who now do understand it that I shouldn't have understood it because it didn't make any sense then. As to whether the court has, so I really am in no position. All I can tell you is hearsay, Senator. From those who follow the field, I do understand that the rules have changed in recent years and that the court is applying the principles and the data that economists have accumulated over the years regarding the sensible application of the antitrust laws. But I haven't had a single antitrust case since I've been on the D.C. Circuit, and I haven't complained about that either.
Judge Scalia, Chief Justice Berger, and others have complained about the poor quality of advocacy before the nation's courts, including advocacy before the Supreme Court. Do you feel that legal representation is poor? And if so, what, in your opinion, should be done to improve the quality of this representation?
Senator, I can only speak for my own court, and before my court, it's excellent. I can't speak highly enough about the bar that practices before me. I think an enormous proportion of highly competent lawyers who do fine work not only for their client but for the court in informing us of the issues of law that we have to decide. On the basis of what I see before my court, which is maybe not a typical court, the advocacy is good.
The distinguished senator from Massachusetts.
Thank you, Mr. Chairman. Our ranking member, Senator Biden, is currently on the floor with the introduction of legislation dealing with drug regulation, and he'll be over here very shortly, but I'll proceed if I might. Judge Scalia, if you are confirmed, do you expect to overrule the Roe versus Wade?
Excuse me?
Do you expect to overrule the Roe versus Wade Supreme Court decision if you're confirmed?
Senator, I don't think it would be proper for me to answer that question.
I agree with you. I don't think it's proper to ask any question that he's got to act on or may have to act on.
I mean, if I may say why, I'm going to, let's assume that I have people arguing before me to do it or not to do it. I think it's quite a thing to be arguing to somebody whom you know has made a representation in the course of his confirmation hearings, and that is by way of condition to his being confirmed that he will do this or will do that. I think I would be in a very bad position to adjudicate the case without being accused of having a less than impartial view of the matter.
There have been at least some reports that was at least one of the considerations in your nomination. A lot of other clearly strengths which you bring to your own qualifications, but I'm interested in what precedents you put on the fact of that decision being on the law books. How I'm interested in your own concept in the stare decisis. You believe in it? What is it going to take to overrule existing Supreme Court decision?
As you know, Senator, they are sometimes overruled.
I'm interested in your view.
My view is that they are sometimes overruled, and I think that.
But what weight do you give them?
I will not say that I will never overrule prior Supreme Court precedent. I think that's.
What weight do you give the precedent, Supreme Court? I mean, are they given any weight? Are they given some weight? Are they given a lot of weight? Or does it depend upon your view? Which
doesn't depend on my view. It depends upon the nature of the precedent, the nature of the issue. Let's assume that somebody runs in from Princeton University, and on the basis of the latest historical researches, they have discovered a lost document that shows it was never intended that the Supreme Court should have the authority to declare a statute unconstitutional. I would not necessarily reverse Marbury versus Madison on the basis of something like that. To some extent, government, even at the Supreme Court level, is a practical enterprise. There are some things that are done, and when they're done and you move on. Now, which of those you think are so woven into the fabric of law that mistakes made are too late to correct, and which aren't, that's a difficult question to answer. It can only be answered in the context of a particular case, and I don't think that I should answer anything in the context of a particular case.
Well, do I understand that your answer with regard to Supreme Court decisions is that some of them are more powerful or more significant than others in terms of their how you would view in overruling them or overturning them?
Yes, I think so, Senator. May I supplement?
And you're not prepared to say on this issue where that decision comes out, as I understand.
That's right, Senator. And maybe I can be a little more forthcoming in response to your first question. As you followed it up, you said that, some thought that that's why I was going on to the court or something like that. I assure you, I have no agenda. I am not going on to the court with a list of things that I want to do. My only agenda is to be a good judge. I decide the cases brought before me, and I try to decide them according to the law as I can best figure it out. But it's not a programmatic matter as far as I'm concerned.
Well, that's part of this whole process, giving you an opportunity to speak to those questions, but it also is a part of this process to find out what kind of relevancy you give to previous court decisions and how significant they are in terms of your own legal experience and when they might be overturned or when they might not be. And as I gather from your answer, that's kind of a variable, that some have a stronger standing than others, and that's your view. But in terms of that particular view, you're not prepared to indicate, at least in that case, in the Roe versus Wade case, where you come out as to whether you feel that is a strong precedent or a weak precedent. But evidently you believe that some precedents are weaker and some are stronger, and the doctrine of stare decisis.
And nobody arguing that case before me should think that he's arguing to somebody who has his mind made up either way.
Well, then what is the relevancy of the previous decision? Does that have any weight in your mind?
Of course.
Well, can you tell us how much? Or?
That's the question you asked earlier, Senator, and that's
precisely
the question I do too.
Depends on the case, doesn't it?
Well, let me go to another kind of question about that you talked about overruling precedents, and that evidently some have a greater weight than others. I think all of us certainly here are familiar with the decision by the court of the Graham-Rudman case. We're also less familiar, but increasingly more familiar, of the decision in the district court. Some have suggested that you might have been the author of the opinion. Whatever that might be, there's a clear indication about questioning the roles of the independent agencies and the allocation of certain executive powers to those independent agencies. This was, I think, probably decided 1935 as to uphold their constitutionality, and I think maybe you want to comment whether this decision in the district court, how it really fits into that particular holding about the allocations and the authority of the independent agencies.
I don't think it affects it at all, Senator. The three-judge district court decision in Sinar decided the case on the assumption that that the decision in Humphrey's executor permitted the prohibition by Congress of presidential removal except for cause. It was done on that assumption.
Well, there'll I think, be an opportunity, I think, at greater length to go into that particular decision and to try and draw out what the courts are really saying about the continued strength of the independent agencies in terms of their constitutional standing.
Senator,
okay.
Before that happens,
right.
let me tell you a problem I have of discussing it even generally, not in the context of a particular Supreme Court. We have pending, not in the Supreme Court, but before the court that I'm now sitting on, so that it'll be a problem for me whether I'm confirmed by this by the Senate or not. We have pending before us a suit challenging precisely the constitutionality of the restrictions on removal of the members of the Federal Trade Commission.
Right.
So I am very much constrained about
Well,
speaking.
we'll back up a little bit because I'm more interested in your approach to these issues. We have seen very strenuous action in the Congress over the period of 30 or 50 years in terms of creating a safe workplace for the American worker. The Congress addressed the whole abuses in the child labor laws. We've tried to address the issues in terms of sweatshops, other areas where there's been very significant exploitation of the American worker. One of the newer areas where the Congress has addressed is on the issue of occupational health and safety. This is an area which the Congress has spoken very clearly. Nonetheless, the complexity, very few of us in the Senate, I don't think any now, we did have some, are doctors. These are complex issues. And if it's the decision of the Congress and the Senate that these kinds of decisions are going to be relinquished to an independent agency to attempt to provide for what is a congressional responsibility in terms of the protection of the workplace, and that we are going to give that function to an agency that will draft various rules and regulations. I'm interested in how troubled you are about it, because I have reference to an article that you wrote on note on the benzene case, in which Judge Rehnquist had a dissenting comment, in which you also expressed a view, which I would think, if it became a majority position, certainly with regards to the occupational health and safety division, would probably mean that that particular agency would be effectively eliminated. I'm interested in your comments, whether I'm
You're
correctly-
asking now not about removal power, but about
Yes.
excessive delegation.
Exactly. And if I could just add to that, one of the points that you raise is the question of vagueness in terms of the drafting of various statutes. I would just interested as a legislator trying to find out where we're going, quite frankly, with you, Mr. Justice, would also, as someone who spent a good deal of time, know that certain language has to be vague in order to permit decisions by, say, medical personnel to be able to draft certain flexibility. Hopefully they're not vague, but they provide a degree of flexibility in order to get the job done. And I'm just wondering what message we ought to have in terms of the future if we're going to run into problems on this.
Well, again, I'm reluctant to talk about what Scalia will say in the future. I can't talk about what he said in the past, and I think you have me on the wrong side on the matter of
help me out
of broad delegation. The fact is, in the Sinar case that we were discussing earlier, the principal attack on the legislation was that it was unconstitutional because of the excessiveness of the delegation, and the three-judge district court on which I sat rejected that argument. Did not sustain it. The article that you have there, which is an article from Regulation Magazine that I used to be editor of at one period, I think you read it incorrectly if you view it as an attack on the constitutionality of broad delegation. To the contrary, I think if I recollect the article you're referring to correctly, it displayed quite the opposite view, the view that it's very difficult for the courts to say how much delegation is too much? It's a very, very difficult question, and I think it expressed the view that in most cases, the courts are just going to have to leave that constitutional issue to be resolved by the Congress. Congress has an obligation to follow the Constitution as well.
Well, would I be correct in saying that you would support, then, a broad congressional mandate in these areas?
I would support a broad congressional mandate that is not unconstitutionally overbroad. Yes.
Go around and around.
That's all I can say.
The point that
No, but seriously, I'm not trying to go round and round. I think I am accurate in saying that my writings do not show that I am likely to be more restrictive on that matter than others.
it may I may not assume correctly that in reviewing some of these cases and the articles that you require a degree of specificity in terms of the legislation. And an opinion that you're not going to breathe the life into the words or language of various acts. And there's a whole series of different references I could read. I don't want to take the time. That's what I'm concerned about. Obviously, and I'm interested in whatever response you can give. You know the point I'm driving at. You don't want a unconstitutional delegation, but I'm talking about specificity and in areas which I think the Congress has acted in terms of the protection of the elderly, in terms of the protection of health and safety, and in a whole wide range of areas of protections in health and safety. And I'm just interested in how not only the constitutional question of the allocation of powers, but also the specificity that you require in order to permit these to be upheld.
Senator, I think you have me wrong. I have criticized, and I think I've often said in my writings and in my speeches, that Congress should be more specific, that the more specific Congress can be, the more democratic the judgment is, because if Congress isn't specific, the judgment is made by the courts, and the courts are not democratic institutions. So I have criticized what seemed to me as a policy matter, the overgenerality of the statutes. But the reason I've criticized them is precisely because, even though they are overgeneral, they will, by and large, be upheld and implemented by the courts, and the courts will determine what they mean. I don't think that is ordinarily the better way to do it, to the extent that Congress has the time, and I know that's a problem. The import of my earlier writings was that Congress ought to try to be more specific, but that does not speak, Senator, to whether, if it chooses not to be more specific, the law will be unconstitutional.
Okay, that's helpful. In an earlier response to the chairman's questions on the free speech, on the Ullman versus Evans, in your dissent, your conservative colleague, Judge Bork, evidently criticized your dissent, noting that you were, I think he mentioned, abdicating your judicial function by your crab view of free speech. How do you respond to Judge Bork?
Oh, I guess I would respond that my dissent was joined by my liberal colleagues, Judge Wald and Judge Edwards. I'll leave it there.
That's enough for Judge Bork. You had an area that this committee is interested in, and that's a question of executive privilege, being able to obtain certain documents. I noticed in your exchange with Senator Muskie, you're talking about this time, they were talking about the Nixon case. And Senator Muskie concluded in his question, and in your judgment, the right of the Congress to military and diplomatic secrets stand at a lower level than the right of the President to withhold those secrets was a question. You said, no, sir. And then you continued along. I don't mean to denigrate the congressional, I'll include it all in the record, Mr. Chairman, if I may. Got a statement. I don't mean to denigrate the congressional power. They both, the Congress and the executive, have the right to assert their prerogatives. When it comes to an impasse, the Congress has means at its disposal to have its will prevail. The means are indicated in my testimony. The most effective is the withholding of funds from the executive. The refusal to confirm presidential nominees was also used several times under President Nixon. if I recall, to elicit information which had been previously denied. The Senate simply would not confirm nominees until the information was turned over. I'm wondering if you still
Did I say that,
affirm that wonderful judicious statement and comment that is based upon all these excellent reviews that have been given to you. I imagine you still want to hold to that.
It's true, Senator. How can I withdraw from it?
I don't know whether I should ask you whether you want to expand on that or not, or whether
it's one of the means that the Congress has at its disposal.
In another area, Judge Scalia, this is on the questions of national security and individual rights. We have gone through a rather important period in past history in the early 70s, where we were trying to balance national security interests against the First Amendment. And we've seen recent histories taught us to scrutinize the claims of the executive branch when inhibiting the possibility of inhibiting free speech and association of press and right of dissent under the names of national security. And I just was interested in hearing your own attitude, how you as an individual view the role, whether you view the role as an umpire in our federal system, whether the competing First Amendment and between First Amendment and national security claims, or are you going to give the complete basic and overwhelming presumption to those who make the claim, or are you going to examine in some detail the background for such a claim, or how you'll approach the issue generally?
Well, I will certainly approach it with an awareness of the importance of both of the elements that are in contention there. The First Amendment is of enormous importance, the ability of the people to speak, to learn, and on the other hand, the national security is often national security interest is often of great importance. That's the worst problem about being a judge. It's never something on one side. I mean, you can be criticized for coming out against the First Amendment, and one never hears what's on the other side of that case. There is always some important interest on the other side, or it would not be a case. I can't be any more specific in response to your question, except to say that I'm seriously interested in both of the principles, both of the concerns that arise in those cases. I am aware of the importance of the First Amendment, and will give it the full weight that the Constitution accords it.
The reason I bring that up is because when it was alleged and charged for national security reasons, we found the gross abuse of all these individual rights and free assembly during another period, the early period of the 1970s, where we had extensive unauthorized, unconstitutional wiretapping, mass surveillance, and questions of First Amendment rights. I hear my time is up. I thank you. In fact, thank you, Mr. Chairman.
Thank you. Thank you. Stangerson from Maryland.
Thank you, Mr. Chairman. Judge Scalia, as you well know, one of the special qualities that a judge must have is the ability to put aside very deeply felt personal beliefs in order to apply the law and the Constitution fairly and equitably to every litigant who stands before him. Your exchange with Senator Kennedy on the subject of Roe versus Wade suggests an area where you have written, and I'm not trying now to lead you down the pathways of the future, we'll look down the road of the past. But you've written on the subject of Roe versus Wade. And while I don't pretend to be an expert on every word you've written, I believe you have expressed doubts about that decision both on moral grounds as well as on jurisprudence. Is that correct?
I'm not sure. I'm not sure the latter's true, Senator. I think I may have I think I may have criticized the decision, but I don't recall passing moral judgment on the issue. But I agree with your opening statement that one of the primary qualifications for a judge is to set aside personal views.
However it may be with your article on Roe versus Wade, the problem remains. What does a judge do about a very deeply held personal position, personal moral conviction, which may be pertinent to a matter before the court?
Well, Senator, one of the moral obligations that a judge has is the obligation to live in a democratic society and to be bound by the determinations of that democratic society. If he feels that he can't be, then he shouldn't be sitting as a judge. There are doubtless laws on the books, apart from abortion, that I might not agree with, that I might think are misguided, perhaps some that I might even think in the largest sense are immoral in the results that they produce. In no way would I let that influence my determination of how they apply. And if indeed I felt that I could not separate my repugnance for the law from my impartial judgment of what the Constitution permits the society to do, I would recuse myself from the case.
I had a similar conversation with Judge Noonan of the Ninth Circuit at the time he was before this committee for confirmation. And he has very strong feelings on the abortion question. But he came out about the position that you've just expressed, that it would be necessary, if not desirable, for him to recuse himself on cases that touched so closely on that issue in which he had been an advocate and a strong spokesman working in that field.
That's not quite what I've said, Senator. I didn't say that I would recuse myself in the
Well, that's where
program.
I'm wanted to
Yes.
press you to. How would you deal with the problem?
I don't know what Judge Noonan told you. Judge Noonan had indeed written considerably in the field and had been one of the leading advocates.
He was a strong activist
Yes,
in the field and was affiliated with a number of activist organizations.
I don't think I fall into that category.
Under what circumstances would you think a judge who had not had that kind of a background should recuse himself?
Only where he himself is personally convinced that he cannot decide the question impartially because he feels so strongly about the morality of the issue. And it's not at all unusual for justices to have to confront such cases. United States versus Reynolds, for example, which held that it was constitutional for a state to prohibit bigamy. Now, that was certainly a moral issue, the issue of monogamy for the justices sitting on that case. They obviously, at least many of them, must have had religious views about the matter, and they did not feel it necessary, those that had those views, to disqualify themselves. And I don't think that any judge has to, unless he or she is personally convinced that the issue has so beclouded his or her judgment that the Constitution would not be applied impartially. I don't intend to disqualify myself, except where that's the case, as far as the type of question you ask about is concerned.
The way you put it in when you were with us in 1982 was this: I would disqualify myself in any case in which I believe my connection with one of the litigants or any other circumstances would cause my judgment to be distorted in favor of one of the parties. I would further disqualify myself if a situation arose in which, even though my judgment would not be distorted, a reasonable person would believe that my judgment would be distorted. That does not mean anyone in the world, but a reasonable person.
That's right.
Is that the position that you will carry with you from the Court of Appeals to the Supreme Court?
Yes, it is, Senator. And what I'm further saying is that I don't think that reasonable people think that the moral views that judges may hold on one piece of legislation or one decision or another so automatically beclouds their judgment that they must disqualify themselves. I don't think that the records of the Supreme Court could possibly be read to establish that as the basis of disqualification. On bigamy, on capital punishment, on an enormous number of things, the men and women on the court have had strong moral views, doubtless, and have sat nonetheless.
Now, you very carefully, and I think properly, limited this problem by saying that does not mean anybody in the world but a reasonable person. But if a reasonable litigant actually believed that your judgment would be distorted because of some strong personal bias or belief, would that dissuade you from sitting on a case?
USC Section 455, any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned.
Turning to the matter of precedence, as a member of the Court of Appeals, you are bound by the precedents established by the Supreme Court. But you will very soon be in a position to change the precedents, to overturn them. So your view of the value of precedents is important. Justice Rehnquist last week, or as a matter of fact, it was during his first confirmation hearing, he said that a precedent might be less authoritative if it has stood for a shorter period of time, or if it was the decision of a sharply divided court, and he reiterated that view last week. Would you agree with that general sentiment?
Well, I think the length of time is doubtless a considerably important factor. The Marbury versus Madison example that I gave in response to Senator Kennedy. I'm not sure I agree with Justice Rehnquist that the closeness of the prior decision makes that much difference. I mean, if Marbury versus Madison had been 5-4, I'm not sure I'd reverse it today. But I think the statute reads that way, Senator. I have the statute somewhere. I'm quite sure that the way you put it is about the way the statute reads, requiring disqualification, if I may. 28 U.S.C. Section 455, any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned.
Turning to the matter of precedence, as a member of the Court of Appeals, you are bound by the precedents established by the Supreme Court. But you will very soon be in a position to change the precedents, to overturn them. So your view of the value of precedents is important. Justice Rehnquist last week, or as a matter of fact, it was during his first confirmation hearing, he said that a precedent might be less authoritative if it has stood for a shorter period of time, or if it was the decision of a sharply divided court, and he reiterated that view last week. Would you agree with that general sentiment?
Well, I think the length of time is doubtless a considerably important factor. The Marbury versus Madison example that I gave in response to Senator Kennedy. I'm not sure I agree with Justice Rehnquist that the closeness of the prior decision makes that much difference. I mean, if Marbury versus Madison had been 5-4, I'm not sure, I'd reverse it today. But I can understand how some judges might consider that that's an appropriate factor as well. I agree. I certainly agree with the former. The latter wouldn't have occurred to me, but maybe.
One area of law that has produced shifting majorities and some very sharp dissent is affirmative action. Some commentators have noted that after some years of ferment, the court is reaching a consensus. One of those observers is Justice O'Connor. She wrote in a concurring opinion in Wygant versus Jackson Board of Education that the court is in agreement that remedying past or present racial discrimination by a state actor is a sufficiently weighty state interest to warrant the remedial use of a carefully constructed affirmative action program. The court has forged a degree of unanimity. It is agreed that a plan need not be limited to the remedying of specific instances of identified discrimination for it to be deemed sufficiently narrowly tailored or substantially related to the correction of prior discrimination. Now, do you think it's a fair observation that the court's affirmative action decisions represent a fair measure of consensus or a degree of unanimity? So that an affirmative action program that benefits persons other than the identified victims of discrimination is permissible under the Constitution?
Senator, I really don't think I should give my view, and you're talking about an area in which it's a sure thing that they're going to be a lot more. The one thing you can say for sure about the Supreme Court decisions is that they haven't answered all the questions. There's doubtless going to be a lot more litigation in that field, and I don't think that I should commit myself here to a point of view. If that is Justice O'Connor's position and the position of a majority of the court, that does not prove that it will not be argued to the contrary. And I've spoken my piece about stare decisis, but stare decisis is quite different from committing myself to a view before the committee that is responsible for confirming me to the court.
Does the kind of consensus that Justice O'Connor mentions have any precedental value in your view?
Oh, I don't think it all has to be in a single majority opinion. I mean, if you have 3 separate opinions that add up to 5 justices for a particular principle of law, that principle of law has been found in that case.
The chairman raised the subject of the death penalty. I suspect that you have had a minimum number of the petitions on your current court from the prisoners on death row.
Very few, Senator, because we do not have a federal prison within our jurisdiction. It's over in the Fourth Circuit.
Of course, in the other circuits, these petitions are very frequent, and the Supreme Court is constantly confronted with these petitions. And it's been a controversial area of court activity, been criticized on procedural grounds. On the one hand, the death row petitioner usually arrives at the Supreme Court at the end of, as the chairman has suggested, the end of a very long and tortuous road of appeals and collateral attacks and every kind of procedural gambit that can be imagined. And there's a pressure of every sort to decide the petition very quickly and to bring finality to the case, even if it requires summary action. On the other hand, because the penalty is irrevocable, the argument is made that each one of the petitions should be very carefully examined and weighed and the execution date stayed until there has been full consideration. Have you had an opportunity to consider how these competing pressures ought to be balanced? How much process is due to the death row inmate whose petition arrives at the Supreme Court just on the very eve of the day of execution?
Senator, to tell you the truth, that is a subject I really have not given thought to, and it's scary, isn't it? I don't know. I think that must be a very hard call. Can't imagine a more important issue, and you've painted the considerations on the other side. All I can say is I'll do my best.
Well, I think it must be one of the most difficult issues to face any public official, whether it's a governor who has a death warrant presented for his signature, or whether it's a judge giving signing the final order. But it's one area of responsibility that I will not be envying.
No, I don't look forward to that as the most enjoyable part of the job, Senator.
In recent years, the court has very rarely spoken with a single voice in major cases. There have been a proliferation of individual opinions, concurring opinions, dissenting opinions, separate opinions by justices. And many of the cases that address very crucial issues are decided by a patchwork of opinions. The result has some unfortunate aspects. The value of the decisions of the Supreme Court as precedent is diminished, and litigants can be confused about what the law really is, or they may be encouraged to make a second try to get a clearer or more favorable sort of result. Secondly, there is a concern about the effect of these increasingly sharp public disagreements on the collegiality of the court. As a circuit judge, have you found that the proliferation of individual opinions on the part of the Supreme Court has impeded the ability of either lawyers or judges to glean the reasoning to support a particular decision?
Oh, unquestionably, Senator. I don't think there's any doubt about that, including in some very important and difficult areas. I guess the case that comes immediately to mind is the Bakke case on affirmative action, where what is said to be the holding of the court is really the holding of the opinion of only one of the justices, Justice Powell, because there were three opinions, one for four of the justices, Justice Powell, and one for the other four, and the four that Justice Powell joined became the majority, so his opinion is quoted as the opinion of the court. It makes for a very confusing situation. I don't know what the solution is, except self-restraint, I suppose. I have not been notable for writing separately on the court that I sit in. Notable for the quantity, I hope to mean. As you know, other systems get along without it entirely. The European system typically has an unsigned opinion for the entire court, and you either win over the majority to your view, or your view does not appear. One can run a system that way, but that's not in keeping with the rugged individualism of the common law judge, which is a quality I think we want to retain. So I do think you need to leave room for dissents and concurrences. All I can say is it takes some self-restraint, and I hope to bring it to bear.
Well, I don't know that this institution, that the members of the Senate are in any position to criticize verbosity on the part of others, but I see my time has expired.
Distinguished ranking member.
Thank you, Mr. Chairman. I apologize, Judge. I was on the floor with the introduction of another bill regarding the drug problem, and I'm sorry to not have heard your original statements. I want to pursue several areas. I will not be able to get them done in one round, but it won't be too many. Let's start, if you will, with, I have read all the speeches that I could find that you've written, and I find a very interesting, and I mean that sincerely, analysis of the newly enunciated doctrine of original intent. And from your speech, the speeches that I've written, I can't tell, and I'm not being smart when I say this, whether your analysis of your view of original meaning was one you meant, or whether it was done with tongue-in-cheek, or because you start off the speech in which you enunciate your doctrine as saying, when I was in law teaching, I was fond of doing what is called teaching against the class. That is, taking positions that the students were almost certain to disagree with in order to generate some discussion, if not productive thought. I have tended to take a similar contrary approach in public talks. It is neither any fun nor any use preaching to the choir. And then you go on and...
I'm trying to fight against that here, Senator Mike. I'm trying to fight against that inclination here.
Well, let yourself go, because it's pretty boring so far, and it may be more interesting, and we may get a chance to see who you are a little bit more. I'm not suggesting that you are attempting to hide behind the argument that many use, which is that may come before the court, therefore I can never discuss it. Everything may come before the court. There's nothing in American public life that may not come before the court. Nothing. Therefore, if you applied that across the board, you wouldn't be able to speak to anything.
Be happy to explain what the...
Let me back up. Why don't you tell us how you view interpretation of the Constitution? Do you view it as a living Constitution, to use that quote term of art? Do you view it as having to look to the original meaning, the original intent? Who are you, Judge Scalia?
That's a good question, Senator. I am embarrassed to say this. I'm 50 years old, grown up and everything. I cannot say that I have a fully framed omnibus view of the Constitution. Now, there are those who do, who have written pieces on constitutional interpretation, and here's the matrix, and here's how you do it. I think it's fair to say that you would not regard me as someone who would be likely to use the phrase living Constitution. On the other hand, I'm not sure you can say that he is pure and simply an original meaning, or I'll be happy to explain the difference between original meaning and original intent.
I just want to know what you think.
It's not worth it. It's not a big difference.
Well, what do you think?
What I think is that the Constitution is obviously not meant to be evolvable so easily that, in effect, a court of nine judges can treat it as though it's a bring along with me statute and fill it up with whatever content the current times seem to require. To a large degree, it is intended to be an insulation against the current times, against the passions of the moment that may cause individual liberties to be disregarded, and it has served that function valuably very often. So I would never use the word the phrase living Constitution. Now, there is within that phrase, however, the notion that a certain amount of development of constitutional doctrine occurs, and I think there is room for that. I frankly, the strict original intentist, I think, would say that even such a clause as the cruel and unusual punishment clause would have to mean precisely the same thing today that it meant in 1789.
You said it would have to mean that?
Yes, so that if lashing was fine then, lashing would be fine now. I'm not sure I agree with that. I think that there are...
Addressing this problem for me, Congress is presently considering legislation to create, on a trial basis, an inter-circuit panel to resolve the conflicts between the various circuit courts. How do you feel about that?
Well, let me give you the Court of Appeals judge's point of view again. The immediate effect of it, of course, is to render judges who are now sitting on the second highest court in the land judges sitting in the third highest court in the land. And that's not likely to make
How do you feel about it, Judge Scalia?
as a policy matter
Yes.
for the country.
You think it has merits, or you think it's not necessary, or what?
I think it's terrible, and the only question is whether the alternative is more terrible. I don't think anybody is happy about having a four-level court structure. It's more cumbersome. It's more expensive for the litigants.
So unless the case was made that it was necessary, you don't think you ought to do it?
I think that's so, but I don't think that's telling you anything that's very useful. I think everybody.
There has been some debate here as to whether or not those judges should be taken from the various circuits, or they should be appointed by the Supreme Court, or even one suggestion was made in the markup that they be appointed by the President, confirmed by the Senate. Do you have an opinion of what you think would be best for that inter-circuit panel, if indeed it was established, where the judges come from?
Certainly, if it's to be made a permanent thing, it seems to me you should do it right and have the appointments made the way Article III judges are normally appointed to courts, appointment by the President to that court, a nomination by the President to that court, advice and consent of the
How
Senate.
about on a trial basis, which is the way the legislation did pass the Judiciary Committee? Do you have an opinion? I'm only looking for something to help.
Yeah, I don't know. I think it's a close call whether
You're on the bench.
on a trial basis, a quick and dirty trial, you want to do it on some different basis. I could see doing it that way temporarily.
Judge, I've been interested in formulating some way of constitutional provision for judicial discipline, short of impeachment. And the Congress did pass the Judicial Discipline and Tenure Act several years ago, and it was to various circuit courts were to set up a procedure for this. And I knew once, but I've forgotten. Do you know if the D.C. Circuit Court has set up such a procedure?
Oh, yes. I think all the courts have a circuit council now that implements the act.
And do you know the experience of that at all? Has there been many complaints, or?
Yes, I think complaints are many. No, I wouldn't say many, but there are complaints, and the complaints are processed. I'm not sure that the fact that the procedure is not very visible to you or to anyone else means that the procedure is not working. It's working, and maybe the fact that it's working well simply stops many of these things from coming to public attention when they otherwise would.
Do you know that there has been complaints filed and some action taken on them?
Yes, I do.
Do you know if there's been any discipline? I'm not going to ask you who or what, but do you know if there ever been any discipline discussions relating to your circuit or any other circuit?
I don't know, Senator. Oh, I'm sure if you say my circuit or any other circuits, I'm sure there have been.
Well, I'm not aware of any, and I just wonder through the grapevine of the Judiciary Conference, what have you, if you knew of any, and I'm not going to ask you to be specific, or if you did know of any disciplinary actions that have been taken as a result of that.
Well, I think there was one in our circuit. As a matter of fact, at least one.
Many critics of the so-called bureaucracy have been strangely silent, it seems to me, for the last few years. It's almost as if the criticism might have been motivated out of politics. That never happens in this town, we know that. I'm interested to read a regulation
magazine, AEI magazine, your advice to the president concerning the bureaucracy, and you wrote, quote, "Replacing their bureaucracy with our bureaucracy does not solve the underlying difficulty. The point is that no bureaucracy should be making basic social judgments. It is perverse to delight in our ability to change the law without changing, to change the law without changing the law," end of your quote. What do you think can be done legislatively, as an opinion, and what can be done judiciously to rein in the bureaucracy?
Well, let me begin by saying I have never been a bad mouther of the bureaucracy. Most of the people I've known in the government, and I've worked in the executive branch in 3 different positions, most of them are good, hardworking, talented, dedicated people, and trying not to pervert the law, but to the contrary, to implement it. The problem I was addressing there was simply the fact, the same point I was discussing with Senator Kennedy earlier, as a matter of fact, is the problem of excessive delegation. Too many of the basic judgments are simply not made in the statute. They are left to be made by the agency that implements it. To the extent that can be avoided, that's the way to go. Otherwise, when you change an administration without any vote to change the law, suddenly the same law is being administered in a different direction, and that swing can be more or less extreme depending upon how specific the statute
Does
itself.
the judiciary play any role in that?
Yes, I think the judiciary stops the swing from going beyond the bounds of the reasonable. But when it's drawn with sufficient vagueness, even the reasonable swing is a pretty broad one. I'm sure Congress is aware of the problem. It's a hard one to get a hold on. That's all.
Thank you. Thank you, Judge. Thank you, Mr. Chairman.
After Senator Grassley, we'll take a 10-minute recess. Distinguished Senator from Iowa.
Thank you, Mr. Chairman. It's my understanding that much of the work of the D.C. Circuit involves regulatory agency cases and administrative law, and you've obviously thought and written a great deal about those issues, and I think it's fair to suggest that if confirmed that you're going to play a special role in future Supreme Court cases in those areas. I'm interested in the area of administrative law from my chairmanship of a subcommittee here of this committee. Now, I understand you to be an outspoken opponent of the legislative veto. You've criticized Congress for, and these are your words, passing laws with strings attached. Now, I personally disagree with your view because I'm opposed to the tremendous amount of legislating done by faceless bureaucrats who aren't elected by anyone. So I'd like to explore the subject of the legislative veto. What if Congress enacts legislative veto legislation that satisfies, 1, bicameral passage, and 2, the presentment requirements set out in the Constitution? Isn't that about all that's constitutionally required?
Those are the only 2 problems that were raised against the type of veto that was struck down in Chadha. And I suppose if those 2 requirements, if those 2 problems were overcome, the problem would be eliminated. But I'm not sure you'd still call it a legislative veto.
Well, that would then be following upon writings that you've done in the Administrative Law Review Article 70 in 1976, the Regulation Magazine, February 81, Regulation Magazine, December 79, in which you cite only those 2 constitutional imperfections. So your view today then is similar to what you had previously written.
Well, what matters today is not my view of what I previously wrote, but what the Supreme Court subsequently decided. That is, subsequent to what I previously wrote, the Chadha case.
Well,
And
assume again that...
I think you're presenting to me a situation in which the 2 defects discussed or identified in Chadha were eliminated. And, on the basis of Chadha...
assume again that a legislative veto statute then would meet the Chadha test. Don't you agree that a legislative veto serves a virtue in today's age when it's so difficult for Congress to legislate policy statute by statute against a backdrop that we find ourselves in here of constantly changing issues?
Senator, as I told Senator Kennedy, one of the things I've always been concerned about, and my writings show it, is the problem of excessive delegation by Congress to the agencies. It's an awfully hard problem to deal with. To the extent that there is a device that will enable Congress to review more closely the activities of the agency, that is desirable. If there is some way to get proper legislative attention to what the agencies have done by way of implementing earlier statutes.
Yeah. Well, you accept the environment and decide within that environment, I hope that Congress reacts, that we can't anticipate crises, and that I hope you accept that it's unreasonable to expect Congress to do otherwise, and then accept the fact that that's why Congress delegates authority to agency expertise.
No, I understand. I think that's right.
Okay. I think we'd all agree with the Constitution lasting 200 years now, and hopefully for another 200 years, that we have found our founding fathers to be very practical people. I have a hunch that given the range of agencies that we now have today, whether it be FERC or the FCC or the Consumer Product Safety Commission, and you can go on and on, which of course they, writing 200 years ago, could have never dreamed of, that they might find the veto a fair and practical way to deal with the bureaucracy today. Do you disagree with that?
It's conceivable that had they envisioned the kind of a system that would develop, they would have made provision in the Constitution for a legislative veto. Although, as the Supreme Court has said, they didn't. That's what the Supreme Court has said to date.
Well, what the Supreme Court said to date is what Congress passed for a legislative veto up until Chadha, that those forms of legislative veto were unconstitutional. You're said to be a free market advocate who favors economic deregulation, and I made reference to the fact that you'd written for Regulation magazine, and you said you had edited it, and that's kind of a gospel of deregulation. I'm not going to ask you to comment on any specific regulation, but can you give me some indication of what factors you consider when faced with a constitutional challenge to economic regulation?
10 minutes.
I don't recall that I've been confronted with a constitutional challenge to economic regulation during the entire time I've sat on the court I'm now sitting on. Frankly, constitutional challenges to economic regulation are pretty rare nowadays. Most of the challenges are on the basis of whether the statute permitted the economic regulation in question. I really wouldn't even know where to begin to grapple with the question you asked. It's I think I'm not sure that I am sure that the experience of my circuit is not different from the experience of most circuits. It's very rare that economic regulation nowadays is challenged on constitutional grounds.
Well, along that, I'll accept
Equal
that.
protection challenges have just not fared very well in the last half century anyway, and that would be the normal source of attack. And
Well, must the regulation be more than simply wrong-headed for it to be overturned? And
oh, absolutely, yes. It'd have to be more than, and the agency's action would have to be more than wrong-headed to be overturned on statutory grounds as well. It can be reasonably wrong-headed, and we'll approve it.
in a case decided last year, Hershey versus FERC, and that was involving the Equal Access to Justice Act, you took the occasion to comment on what role legislative history and committee reports should play in judicial interpretation. And I hope it's fair for me to conclude that you showed a great deal of hostility towards committee reports in that writing. You wrote in a concurring opinion, and I quote, "I think it's time for courts to become concerned about the fact that routine deference to the detail of committee reports and the predictable expansion in detail which routine deference has produced are converting a system of judicial construction into a system of committee staff prescription." Now, that's pretty doggone strong language. Let me first ask, how important is legislative history to you?
I think it's a significant factor in interpreting a statute. I've used it in my opinions.
Well, let me ask you, how come you don't repeat the usual answer that we get, that, you know, if you do refer to it, if the statute, the language of the statute itself isn't clear to the judges interpreting?
Well, I guess I didn't repeat that because
So obvious?
It's so obvious, and
But you accept the
number one, it's so obvious, and number two, because we normally don't have a lawsuit in front of us if the language of the statute is clear. Almost invariably, the language of the statute is argued to mean one thing by one side, another thing by another side, and where that's the case, legislative history.
Are you going to be then turning to the legislative history then that frequently, as you say that the statute is hardly ever clear?
I will use what seems to me reliable legislative history when it's available to be used. The trouble in legislative history, Senator, is figuring out what's reliable and what isn't reliable. That's the trouble with it.
Well, I want to tell you, as one who served in Congress for 12 years, legislative history is very important to those of us here who want further detailed expression of that legislative intent. You're not suggesting that for committee reports to have any meaning, that they must be actually written rather than merely approved by members of Congress? Are you suggesting that?
Well, I don't want to pin myself down to a commitment to use any particular type of legislative history or not to use any particular type of legislative history. I'm just saying I will not exclude it as a basis for my decisions, as I have not in the past, and that it depends on what the snippet of legislative history is and how genuine a representation of the congressional intent it seems to be.
Well, let me be a little more specific. When you decide a case and look to the legislative history to help you, is it meaningless for a committee report to suggest that a court has misinterpreted an earlier statute and have that statement be meaningful to you?
In the Hershey case that you're talking about, it seems so to me because the statute hadn't been changed. The statute was reenacted unchanged, although it would have been easy to clarify the provision that was ambiguous and that had been the subject of the earlier court decision. What happened, it seemed to me, as best I could read the legislative history, was that the body as a whole had no intent concerning that earlier decision, probably didn't even know of that earlier decision. But the committee at most, and perhaps only the committee staff for all one knows, did have views about that opinion and put it into the committee report. But it is, of course, the view of the whole Congress that counts. Now, if the act had been amended in some respect, and if this statement in the committee report were an explanation of why that amendment, which came out of the committee, was suggested, then it would have had more weight. But here, the statute was enacted entirely unamended, and the statement in the committee report seemed to me almost a dictum. It had nothing to do with the bill that was on the floor.
Well, I think the facts are that there were a number of changes made in successive reauthorizations to that legislation.
No, but I said unamended in the respect that had been the source of ambiguity, which was the subject of the prior court decision. Yes, the act was amended in other respects, but there was no amendment to which this particular language in the committee report had any relevance.
Would it be improper to ratify, so as to speak, a correct court decision by Congress stating that in the committee report?
Can Congress ratify a court decision?
Well, what I'm saying to you-
Congress can only act, Senator, Congress does not act in committee reports. I will say that flat out. Congress acts by passing a law. The only value of a committee report is...
I'm speaking to the point of Congress accepting a view of a court decision and expressing that in the committee report, and then that being legislative history towards what Congress intended to some extent. And I'm talking about a correct interpretation.
I think that the statement in the committee report would have to be an explanation of something that Congress did in the statute. If it were an explanation of something that Congress did in the statute, and it shows that what Congress did in the statute was based upon thus and such an interpretation of a prior, or an acceptance of a prior opinion, then it would be of value.
Well, suppose Congress sees two different court interpretations of the same statute, and Congress says this is the one that we intended.
In the law? No problem.
In the committee report, as a statement of congressional intent.
I wouldn't think that was of any relevance unless Congress had done something in the law of which that statement in the committee report was an explanation.
Suppose it's Congress's judgment that what we said 5-10 years ago is exactly what we intended, and we still intend to say it. It doesn't need a change in the statute, and we're saying with two court decisions with opposing views of that this is the one we like. What's wrong with that as a judgment by Congress of telling the courts how we want the statute interpreted in the future time?
If I could know that that's what the whole Congress meant, there'd be no problem about that at all. But I don't know it when all I see is a single committee report. I can't tell that that's what the whole Congress meant, just from looking at a single committee report, where Congress has taken no action on the face of its statute to which that report is somehow tied, which that report explains, where it's just passing a law that, and the committee that happens to have jurisdiction over that area makes a comment.
Well, obviously, we're talking about a committee report that would follow legislative reauthorization or some other form of congressional enactment for that specific Congress by which the report came.
Yeah, but my only point, Senator, is I don't think that gives the committee the right to opine on all matters pertaining to that law, not to those matters which the committee is bringing before the full Congress. And mind you, all I'm seeking to do, and it's a problem for any judge using legislative history, is to try to figure out what the intent of the Congress is, and to what extent this expression, whether it be on the floor by a single senator, that's a problem sometimes too, or whether it be in a committee report, whether that genuinely represents what the whole body intended, so that we're sure we're not disenfranchising the Congress and getting you as a member of the Senate committed to a position which in fact you knew nothing about and would disagree with.
Well, the reason why I ask these questions is that I think I detect something in your writings, whether it's on the Graham-Rudman, the legislative veto, or this example I just gave. I sense a very critical view of how Congress tries to get things done. Can you address this concern, whether or not you think I'm being too sensitive about it?
Now, honestly, Senator, I have no criticism whatever about the way Congress tries to get things done. You can get things done any way you like, and that's your affair. And I understand the problems that you confront in trying to get it done. The problems that you tried to grapple with a legislative veto, and the kind of problems you're referring to that can be handled by committee reports.
Your background's primarily academic. You've also had a stint in the executive branch, but you never served in the legislative branch, and of course I'm not suggesting that you should.
I'm sorry I didn't, Senator. I frankly have gotten a good look at the territory of the law. The one slice of life I didn't get a peek at was Hill work, although I dealt with the Hill to some extent when I was in the executive branch.
Okay, I'd like to ask if you think that fact that you haven't served in the legislative branch might explain a lack of deference to the methods of the legislative branch in how we choose to do our job, within the political constraints that we have to account for here.
No, I don't think so, Senator, because some of the criticisms I've made about committee reports, for example, have been made by members of the Senate. And you certainly couldn't explain it that way as far as their criticism is concerned.
But there isn't one of those senators that might criticize a specific committee report that takes the same, that shows that same lack of respect for committee reports, because they would be involved with committee reports in almost every piece of legislation that comes before them and that they have to vote on. Mr. Chairman, I have no more questions.
I asked you one more question.
What?
Oh, you're through. We intend to take a recess right now. I understand we're going to have a vote in the Senate in a little bit. We have to take a recess then. So if you don't object, we'll go on for a few more minutes, if that's all right with you.
Mr. Chairman, can I just ask one question before you do? If we don't have a vote, the vote is put off, what will we do then?
We'll stop for a recess. And we'll try to find out when the vote's coming. Are you next?
I was next, I just didn't want to delay the committee when
Well,
we
you
go
can
back in.
you can go ahead now then.
No, I won't,
Scheduled momentarily.
well, then why don't we wait? Why don't, because Judge Scalia's also had a long time here.
Well,
I'm amenable.
I'm perfect.
10 minutes, so we won't save all the time we can. And he says he's willing to go in a few more minutes. You want to go now? If
Makes
not,
no
I'll call on
difference. What's
Senator.
best for you?
Yeah, I'll call on you now.
Thank you, Mr. Chairman. I think one of the problems we've had is that the chairman's absolutely right in saying that vote's been scheduled, but they keep putting it off and off and off. That's part of the legislative, part of that legislative procedure that you and I have discussed in the past too. Judge Scalia, yesterday's Wall Street Journal quotes Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit as saying the words fairness and justice are terms which have no content. I'm interested in your view. Is the word justice one that has content to you?
Oh, yes, I think, of course, I think it has a content. I'd be surprised if what Judge Posner meant was not simply that, at least at the margins, and it's usually at the margins that we're talking when we have litigation in front of us. People disagree as to what justice requires, but I believe it has content, and fairness has content.
I ask that only because it jumped out at me when I read that, knowing that the first line of the Constitution says, "We, the people of the United States, in order to form a more perfect union, establish justice," and so on.
He shouldn't have put it that way. Should have known better.
I suspect he probably feels that way today, too. Maybe the Wall Street Journal, as Judge Heflin said.
I'm sure he doesn't mean anything different either, Senator.
Judge Scalia, you've been an outspoken critic of the Freedom of Information Act, and you've written and spoken out against the 74 amendments to FOIA. At the time these amendments were passed, were you the Assistant Attorney General in the Office of the Legal Counsel?
Yes, I was.
Did you have an opportunity to review those amendments and recommend to President Ford whether he sign or veto those amendments?
Yes, I did.
And what was your advice to President Ford?
Is this public knowledge, Senator? I don't know. If it's not, I think I probably shouldn't disclose it unless the President wants me to. The President vetoed the amendments, and I think he set forth in his veto message what his principal concerns were. The major one was the requirement of the amendments that courts review de novo justifications for withholding on the basis of national security.
Is it saying, do you agree with that veto?
Come to the same question. Do I now? Now doesn't
do you
make
now
any
agree
difference.
with that veto?
I don't have any views on such matters now, Senator.
Did you agree with the veto at the time?
Senator, I have no compunction in answering at all, except the attorney-client relationship that I had with the...
Let me just ask, on your own personal legal opinion, did that veto comport with your own personal legal views of the Freedom of Information Act?
I think it comes to answering the same thing, and I really... I think I shouldn't, in deference to the attorney-client relationship that I had with it.
And I'm really not trying to find just
I've criticized those amendments, Senator. I think you have in front of you, I mean, I'm in print as having criticized those amendments. I might also add, however, that when I was chairman of the Administrative Conference of the United States, I testified before Congress in favor of proposed amendments to the Freedom of Information Act and in favor of proposed application of the Freedom of Information Act by the agencies that were in the direction of liberalizing some disclosures. So
But going to the 74 amendments, which you did write about and which you spoke out against.
Yes.
The president then vetoed these amendments that you wrote about and spoke out against.
Yes.
The Congress overwhelmingly overrode that veto.
I think they
because of that, would you have any difficulties in upholding the law as it's currently written?
No, none whatever, Senator. I've upheld it as it's currently written. And I'm not sure whether Congress simply overrode the veto or did they make one minor change before they overrode? No?
You vote up or down on the veto, Judge.
Okay.
We don't even get a chance for the the staff to go in and write a report.
But they could. That's right. I suppose that's right. They did override and not pass an amended bill.
When we discussed this, am I correct in summarizing our conversation that you said that the law Sense Board not was clearly written and that Freedom of Information Act cases which you have heard were never particularly difficult to resolve?
Oh, no, no, you must have misheard the latter. Some of the most, I can name a couple, some of the most complex cases I've had were FOIA cases. I think
Was that because of the facts or because of the law?
Both, but probably more often the law. Church of Scientology is one of the cases. I commend it to your attention as an incredibly complex opinion, both the panel opinion for 3 judges which I wrote and the in-bank court opinion which I wrote. And it's one of the most complex pieces of statutory interpretation that I had to set my hand to.
Do you find the Freedom of Information Act a clear act, irrespective of how you may have felt about it, felt about the 74 amendments? Do you find it a clearly written act?
No, I would not. I would. If you asked me for an example of a vague statute, the Freedom of Information Act is not what I would immediately pick out. There are some areas where, after I guess a couple of decades of experience now, the statute could be made more precise. But if you asked me for a vague statute, that is not what I would mention as a prototype.
FOIA was enacted before I was here, so I have no pride of authorship one way or the other because I'm not involved in it, but I do want to. It is an act that keeps coming back to us, and it's one that I've been very involved with since. And then do I understand that the act is, at least as acts go, a clear act? It is not a vague act.
I don't know what you mean by almost any piece of legislation. You can say that there are some areas that could be more specific. There are certainly some portions of FOIA that are like that. How specific Congress wants to be, is always a question in every statute. The problem with FOIA, Senator, is that unlike most statutes that Congress passes, it isn't addressed to a single agency, so, addressed to OSHA or to the Food and Drug Administration, so that even if it has a certain amount of vagueness, you're going to get a standardized interpretation by one single agency. The problem with FOIA is that it goes out there to every agency in the executive branch. So to the extent there's any vagueness at all in FOIA, that vagueness is going to have to be resolved at the district court level, because each agency might resolve the vagueness somewhat differently. Now, the Justice Department tries to, at least it used to in the days when I was there, try to get the agencies to come up with a uniform interpretation, but I think you can say that there's special need for precision when you have a statute that is a cross-cutting statute.
But there are a lot of acts that go that way. A lot of your employment acts and employment practices and so on are the same way.
I think that's so, although most of those are much more detailed than FOIA. I have no particular, I don't know what you're driving at. I guess what I'm saying. I suspect that there's some legislative proposals to amend it.
No, I just said,
I really have no
I'm
access
concerned
on it.
about the FOIA. You will be having FOIA cases, I'm sure, before the Supreme Court. Aware of your opposition in 74, and I want to know if that, in your mind, does that opposition create a problem for you in hearing FOIA cases now?
No, Senator, I was asked that question earlier, I think, when you were out of the room, and one of the things I said then, and I stand by it now, is that to the extent that I've made significant law in the FOIA field, I've had a lot of FOIA cases, I don't know what the score is, but to the extent I've made significant law, I think it is in the direction of broadening access rather than restricting access, which...
I'll go back to the transcript of your earlier answer. One of the problems that happens to us in all these things, we have 4 or 5 matters going on at once around the corner of the Appropriations Committee meeting, on which I also serve.
I understand that.
Handling matters there. Judge Scalia, do you recall, well, I recall it was just last year, the Western Union Telegraph Company versus FCC. There was a case involving AT&T and MCI.
Yes, I do, Senator.
And were you asked to recuse yourself in that case by any of the parties or litigants?
No, I was not, Senator.
In '82, you were not on the bench. You'd received a consulting fee from AT&T in an antitrust case between them and MCI. Did you feel that that was close enough in time or significant enough in involvement to call upon yourself to recuse yourself?
No, I didn't, Senator. I had not been counsel for AT&T. I mean, I had not had a long-standing attorney-client relationship with them or anything like that. I had simply done a one-shot job of consulting with them, I guess 2 years or so before I went on the bench, and the compensation may have been just the very year that I went on the bench. And once before, I had taught a seminar for some of their executives about communications law one afternoon. That was the only association I had had with them. It seemed to me that 2 or 3 years disqualification from AT&T matters would be more than enough to eliminate any appearance of impropriety. In all of these cases, of course, it's not just a matter of an interest on just one side and no interest on the other side. It's a cost to the court when I have to disqualify myself, of course, and it's unfair to the litigants. If there's no proper reason for disqualification, they're entitled to get a shot at the full bench of judges and not just at the full bench minus 1 or 2. So I decided that I would recuse myself for a period of 3 years. I informed the clerk of the court that I would not participate in any AT&T matters. That means that I'm, as a practical matter, disqualified from all common carrier litigation, which is a good chunk of D.C. Circuit business. After 3 years, I instructed the clerk to put me back in the pool for AT&T cases.
You do not agree with Mr. Friedman, the former dean of Hofstra Law School, who disagreed with your refusal?
No, not at all, Senator. And I don't know anybody else that agrees with him either. I've had nobody that has told me they thought that 3 years' worth of disqualification for that kind of prior financial connection with AT&T wouldn't be more than enough.
In another case, you wrote the decision in Block versus Meese, which dealt with the labeling of foreign films as propaganda. One of the 3 films involved in let's see, one was an Academy Award-winning film on nuclear war, two dealt with acid rain. In the decisions, I said labeled them as propaganda. Now, next term, as I understand, the Supreme Court will hear a California case, not a DC case, but a California case dealing with the same issue and, in fact, the same films. Is that one that you would feel that you should recuse yourself on?
I've been thinking about that, Senator. What do you think? I think it's a close one. It's not the same case. It's just the same issue of law, but the case is really.
I've not
it's-
given the
yeah.
sense of the question of
I know.
recusal much of a mind. I don't think that I'm on President Reagan's short list for judicial nomination.
No,
Even though he'd have a chance to get both an Irishman and an Italian at the same time. But
yeah, I'm. All I can say, Senator, is I'm thinking very hard about disqualifying myself from it. They are the same films, not the same parties in the litigation, but it are the same films, not just the same issue, but the very same films involved. I think I will probably disqualify myself, recuse myself.
I might say only because
I wouldn't want to argue to me in that case.
I understand.
After
Only because you had asked me the question on it. I would reach the conclusion the one should recuse himself.
In for a nickel, in for a dime. I may as well, yes, I will recuse myself, Senator. I feel uncertain enough about it that I don't think I ought to go near it.
So I look at it this way, it'll probably get you out of having to watch the films again.
I never watched the films. That was not part of litigation.
Back in an area, and I would like to go into, you served under Attorney General Levy, who conducted a pretty extensive review of the domestic security program at the FBI and the Justice Department. He ultimately issued guidelines as to the appropriate scope and conduct of domestic security investigations. They were revised by Attorney General Smith, but they're basically the same guidelines. The Levy guidelines are basically what we use today.
Oh, I don't think so, Senator.
No?
No.
How do they differ today?
Well, I don't know the extent of the difference. All I know is that the intelligence community, so-called, did not like the Levy guidelines at all, and that the Smith guidelines were thought to be more acceptable to them. I know there are differences. I don't know what they are.
Wearing another hat, I deal with those same intelligence agencies, and I don't see an awful lot of difference. That's why I was curious what you might.
I've been out of that field for a long time, except that I know that some of my former associates in the intelligence community dearly did not love the Levy guidelines, and I think I thought that some of the impetus for the changes was from those people.
Did you work on the development of those guidelines?
I believe that Mary Lawton, who was my deputy at the Office of Legal Counsel, was the prime worker with the Bureau and the other intelligence agencies in developing the guidelines.
Who's still involved in that field?
I'm sure Mary has now gone on from the Office of Legal Counsel to, I think, a whole new post just dealing with intelligence matters.
Did you have any occasion during that time to consider whether Congress had the constitutional authority to legislate restrictions on the scope and conduct of such investigations?
Did I have any? I don't think I had any occasion to consider it, Senator, because I don't think there's any question that Congress does.
I'm sorry, I didn't hear that last.
I'm not aware that it was ever in question that Congress had authority to act in the field.
Was the FBI's COINTELPRO program underway when you joined the Justice Department? I'm having a little trouble recalling myself when it ended.
Oh, I'm sure it was all over by then, Senator.
Did you have any occasion on the Office of Legal Counsel to render opinion as to the scope or the authority or the legality or domestic security investigations generally that you recall?
Not that I recall, Senator. Not that I recall.
In the standard questionnaire, an area that I always find of interest, judges are asked is, quote, what actions in your professional and personal life evidence your concern for equal justice under the law? And you answered the question in part by referring to your work in support of legislation to overturn the doctrine of sovereign immunity. Can you describe the kind of work you did as assistant? Oh, I'm sorry, Mr. Chairman, I didn't realize the time was up.
Distinguished senator from Alabama.
Judge Scalia, Senator Grassley asked you about legislative history and bearing downright hard on the issue of the committee reports. I've had the privilege of reading some of your writings, including a speech that you delivered between the fall of 1985 and spring 1986 at various law schools.
That was the speech,
Speech
Senator,
on
right?
the use of the legislative history, not your dissent. And just to refresh your recollection, because I sort of agree with you on your priority that you give to the committee report. You quote from a Senate debate, floor debate on the tax bill in 1982, where Senator Armstrong and Senator Dole are involved in it, and Senator Armstrong points out the fallacies of what the committee report does, and involved in it just for everybody's edification. He said, he asked him, did any senator write the committee report? And Dole answered, I'd have to check. Does the senator know of any senator who wrote the committee report? He said he might be able to identify, but he'd have to search. And he said but he goes on to say staff. And he said, has the senator from Kansas, the chairman of the Finance Committee, read the committee report in its entirety? Senator Dole answers, I'm working on it. It's not a bestseller, but I'm working on it. And then he said, did the members of the Finance Committee vote on the committee report? Senator Dole says no. And Senator Armstrong says, Mr. President, the reason I raise the issue is not perhaps apparent on the surface. Let me just state this. The report itself was not considered by the Committee on Finance. It was not subject to amendment by the Committee on Finance. It's not subject to amendment now by the United States Senate. And you mentioned, and Senator Armstrong goes on and he says, for any jurist, administrative bureaucrat, tax practitioners, others who might chance upon the written record of this proceeding, let me just make the point that this is not the law. It was not voted on. It is not subject to amendment, and we should discipline ourselves to the task of expressing congressional intent in the statute. That's from the congressional record, July 19th, 1982. You state ironically, but understandably enough, this is in your speech, the more the courts have relied upon committee reports in recent years, the less reliable they have become. And then at the end of your speech, you state this, for the purpose, I suppose, I would rank most highly legislative history consisted of amendments defeated on the floor, where it appears clear that the reasons for the defeat was a rejection of a particular course, now said to be contained in the unamended text. I suppose next to that would be extended floor debate, at least in circumstances which occasionally occur where the final text is actually being crafted on the floor. And then you state at the bottom of my list I would place what heretofore seems to have been placed at the top, the committee report. So I think you've expressed pretty well in your speech there the reason why the committee reports are not given a great deal of credence relative to legislative history.
I'm glad Senator Grassley's not here, though, Senator.
Well, maybe his staff will tell him, and I'll talk to him a little bit about it, but I thought that might be interesting to clarify and why. I think, frankly, that there has been too much reliance by congressional bodies on the committee report, and I've been one that's been arguing that is a wrong practice. Let me ask you this, in the Washington University Law Quarterly, you stated in an article entitled The Disease as Cure. This is a commentary on in order to get beyond racism, we must first take account of race. You state that I am in short opposed to racial affirmative action for reason of both principle and practicality. And you went on to say that I strongly favor what might be called, but for the coloration that the term has acquired in the context of its past use, affirmative action programs of many types of help for the poor and the disadvantaged. Judge, would you define what you meant by principle and practicality in the first quote, and what type of affirmative action programs you do favor?
Well, as to the latter, I think what I was saying is that there's, let me set it in context once again, Senator. This was not when I was a judge. It was a speech I gave. In fact, it was on a panel at which now Judge Edwards, who was then also an academic at the University of Michigan, was another one of the panelists, and it was a panel about affirmative action as a policy, not its constitutionality, not its legality, and I was speaking as a, in those days, a law professor who could have views on such policy matters. When I said I would favor certain types of affirmative action programs, I was referring to affirmative action programs in favor of the poor and disadvantaged, even when it turned out that every one of the poor people or every one of the disadvantaged people favored by a particular program turned out to be of a particular race. I said that would, of course, make no difference. But the basis for the affirmative action, the basis for the favoritism, was the poverty or the disadvantage. What I expressed myself in opposition to on policy grounds was favoring a group solely on racial or ethnic grounds and not on basis of poverty or disadvantage. As to the practical and principled problems I found with the latter type of affirmative action, one of the things I mentioned, I guess the two things are, number one, when you favor one person because of his race, you are automatically disfavoring another one because of his race. And I think the second consideration I pointed out was that to an extent it deprives the members of the race who are given the special advantage of the fruits of their labors, because they are sometimes regarded as having achieved those fruits only because of affirmative action, whereas they could have they could have made it without it, and there's no way that they can demonstrate that. Those are, as I say, policy views of mine at the time. I think they're views held by other reasonable people. They're views disagreed with by the Congress, and that's why one has a Congress. Those views have nothing to do with the way I will apply whatever affirmative action laws are enacted by the Congress.
In your questionnaire, you list your various positions and jobs, and you mention in quoting from your page 13 of your questionnaire, it says, in my final executive post as Assistant Attorney General for the Office of Legal Counsel, September 1974 to January 1977. I was wondering if you recall any of the congressional testimony pertaining to executive privilege, to whom it was given in Congress, what the House or Senate or and the committee, any time pertaining to that.
in both houses, but I'm sure I can get that for you. I'm sure it's
You
all a matter
remember
of
what
public...
the issue was about or how the circumstances arose?
I think mostly it was executive privilege in general. The whole doctrine of executive privilege was then at issue with regard to a number of different matters that the Congress had on the stove with the executive, and I don't recall right now any specific issue of executive privilege where it involved the withholding of any particular document or set of documents and where I was testifying. But I can get it for you. I'm sure there's a record of it. All that testimony is...
Well, I'm sure there's a record. I thought maybe you might give us enough to identify where we might look to see what you might have said pertaining to that at that particular time. You don't remember what the
I
issue
don't
was
remember.
that brought you to Congress?
No, at the time, Senator, I remember I think I was on a panel. I think it was a panel before a committee concerning whether there was any such thing. I mean, this was before the Supreme Court's decision in the United States versus Nixon. So there had been no court decision which, in so many words, had affirmed the existence of such an animal as executive privilege, and it was a matter of great interest to the Congress at that time. I was on a panel, as I recall, with Raoul Berger from Harvard, who was an opponent of the existence of any executive privilege.
Express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedures required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. I mean, it's always a...
The legal counsel, whether or not he had issued an executive order which, in an effect, express the viewpoint that that cooperation with Congress should be followed, and that Congress should be allowed to see all documents except, and then list the exceptions that at the time had the president that you were serving under, who I assume was Ford, and were you also under Nixon as
No, I didn't serve under President Nixon. He was out of office before I was confirmed.
Well, did President Ford at that time issue any executive order which, in effect, described and limited the use of executive privilege?
Yes, Senator, but not in the manner you described. The way it was limited was not describing the subject matters, but rather describing the procedure for its assertion. And the procedure was a rigorous one. It could not ultimately be asserted by an executive officer without, as I recall, the approval of, I think it required the President's personal approval before it could be asserted. So it's a big deal. The executive branch does not take it lightly. Now, very often when an agency is asked for documents, it'll say, we're reluctant to turn them over, and there's a preliminary process of negotiation. But if it really comes down to hardcore, adamant positions on both sides that can't be resolved, before the agency can say, we will not comply with the subpoena for the documents, we will not turn them over, the procedures required that there be, as I recall it, approval by the President with the advice of the Attorney General on the matter. And as far as I know, I'm quite confident that that's still in effect, or something like it. We didn't take it lightly, Senator. It's always a regrettable confrontation between the two branches.
Mr. Short, we got to vote on, is it?
Yes, sir, the chair would like to recess it here.
All right.
What we will do is, once you finish your questions, is to recess. We're also going to have a meeting of the Judiciary Committee at
Right after.
Well, I have several other questions I want to ask. If I still got time, I'd rather come back and do it.
How much time does Senator Heflin have?
Well, we still have time before the 5-minute vote. So
I got 15 minutes left. I didn't take it 5.
You have 5 minutes left.
You have 5 minutes left.
That's wrong.
If just one inquiry, when we start off tomorrow, are we going to recess and come back in later this evening, or come
Only
back
until
tomorrow?
5:15, Senator. We'll recess until 5:15.
5:15, okay.
Start again at 5:15.
In other words, we're going to recess now to 5:15?
Yes, sir.
Unless you want to finish your 5 minutes.
No, I'll come back. We'll recess
Well, then
now.
we will recess, and then this might be an indication, Judge Scalia, that notwithstanding the dire prophecies that you are going to be faced with a mass of vultures up here, it shows you how relaxed everybody's been. It's got all the way down to having me as acting chairman at this point. We'll stand in recess at 5:15.
About certain documents that the Democrats wanted to see that are contained at the Justice Department concerning Justice Rehnquist. I appointed the able and distinguished senator from Nevada, Senator Paul Laxalt, to work with the Democrats, see if it could be worked out. They have reached an agreement, and I'm going to request Senator Laxalt now to announce their agreement.
I thank the chairman. We've been working for several days, and by we I mean most of the members of this committee, in an effort to try to work out a compromise in connection with requested documents. And what we've had is a classic conflict between the executive and the legislative branch. Very frankly, the problem was not so much a lack of cooperation on the part of the executive. They wanted to cooperate, but they didn't want in the process to create harmful precedents or get in the way of the whole executive privilege doctrine. So as a matter of scope, what documents would be produced under what circumstances? And after endless negotiations, actually, I look back on it, I think the Marcos mission was a cakewalk compared to this one. As someone pointed out, I did have several more Marcoses to deal with in this situation. But we have finally arrived at an agreement defining the documents that would be made available for justice or by justice to the membership of this committee and certain staff. That examination will be conducted immediately, starting tonight, and sometime tomorrow the senators will be meeting to discuss staff recommendations and questions. The long and short of it is that the conflict has been resolved. In my objective opinion, the needs and desires of this committee and the legislative branch to conduct a full and complete inquiry has been properly balanced by the need of the executive to protect confidential and sensitive documents within the exercise of executive privilege. So what we have essentially here is a rolling back, a limited release of the imposition of executive privilege. And I think, Mr. Chairman, that we have a good compromise. And I'd like to compliment and thank and commend the various colleagues who worked with me for these last several days.
Mr. Chairman.
Go ahead.
Mr. Chairman, I'd like to publicly compliment Senator Laxalt. I quite frankly think with Senator Laxalt's diligence to the subject that allowed a result to be produced because everyone trusts him. The administration trusts him. I trust him. All my colleagues trust him. Number one. Number two, you should not be misled by the comment of Senator saying limited. We are getting an access to all we asked for. Everything we asked for is being made available under the circumstances provided. When I say everything, in the last request, there were 7 categories we set out.
I was speaking of the first request,
yes, I know. I just didn't want the press to come up and say, well, what didn't you get that you wanted? From our standpoint, from my standpoint, the administration is not holding back anything with what is relevant to our inquiry here. As you pointed out, there have been several staff designees, 3 in the majority, 3 in the minority, who'll get a chance to look at this. And every senator has a right to look at them, and I know that we intend on looking at them, and we will late tomorrow afternoon, early evening, do a final review of those documents. And the last point I'd like to make, in fact, it wasn't merely Democrats who were requesting these documents. There were 10 people on this committee, including 2 Republicans, who felt it was important that these documents be produced. I compliment again my colleague, Senator Laxalt, and the chairman for his good judgment in appointing Senator Laxalt, and the Justice Department in cooperating. And as far as we're concerned, unless any of my colleagues wish to speak, the matter has been amicably resolved.
Just for a moment, Mr. Chairman, and I don't want to delay the further consideration of Judge Scalia, but I, as one of the 3 members of this side that initially requested these documents, and as one that made the statement that the administration's position of executive privilege, that they were basically stonewalling the committee and the American people and permitting the Senate of the United States to perform its function in advising and consenting under the Constitution on the particular nominee. I welcome the reversal of the administration to those requests. I believe that these requests were not being made in behalf of individuals. They are being made in behalf of the Senate Judiciary Committee, in behalf of the Senate, on behalf of the American people, so that we could fulfill our function. We'll have an opportunity to examine the various documents, the memoranda, the various notes, all of the information relating to matters which Mr. Rehnquist had recused himself as a Supreme Court justice, the May Day demonstrations, wiretapping, the whole Laird versus Tatum case, and other measures involving civil rights and civil liberties. I believe that this is a very substantial victory for the Constitution and for the constitutional process, and for the American people and for the Senate. So I want to just regret it's taken us the several days to get to this far, but I welcome the fact that we are here, and I too want to join in commending those that spent the time and the effort to assure that we are going to gain that measure. I want to make it very clear at the outset, in reviewing the various holdings on the issue of executive privilege, didn't feel that the argument that were being put forward by the Office of Legal Counsel held water. I don't think it holds water on the requests that have been made by Senator Nunn in terms of trying to gain various information with regards to our negotiating position on ABM. The Soviets have it. The negotiating debates and discussions and notes, the Senate of the United States has denied it. And I welcome the fact that we have made progress in this area, and I'm very hopeful that the soundness and the responsible attitude which has been assumed now by the department will apply to other areas so that we can truly fulfill the mandate of President Reagan when he said that when information is requested by the various committees in order to fulfill their responsibilities, they will be able to receive it. Thank the Chair.
Mr. Chairman. Senator Messenbaum.
Chairman, I just want to say publicly that I think the one individual and American people owe a great debt of gratitude, Senator from Nevada, Paul Laxalt. Because I don't think there's any secret about it that this issue of the confrontation on the matter of executive privilege was rapidly escalating to the point where it was about to becloud the entire question of the confirmation of Justice Rehnquist. And I feel certain that if Paul Laxalt had not inserted himself into the issue at the request of some of us, I think that it would have gotten out of hand. I think there would have been proceeded to the matter of subpoenas and the entire unraveling of that kind of issue. I think Paul Laxalt has served the nation well in not permitting that to develop. I think the President owes him a great debt of gratitude, and as his reward, I think he ought to send to South Africa to get some matters resolved over there. But I think that's just a fine way for you to conclude your career in the Senate, Paul, but you've done a great job on this. I'll say
Thank you, Howard. You're all hard.
Any other comments?
Well, I'd like to
Spoke a
second
few
it.
minutes.
I tell you, if y'all keep talking like it, you're going to give him the big head. He might decide to run for president.
When I spoke a few minutes ago about the Democrats asking for documents, I should have said a majority of the Democrats. There were 2 Republicans on our side, Senator Specter and Senator Mathias, and I want to make that correction. Any other comments? If not, now we will continue with the hearing. And Senator Laxalt, we thank you again for your good work.
Thank you, Mr. Chairman.
Senator Heflin, I believe you have 5 minutes remaining.
Judge Scalia, a lot has been written in the paper about your belief in federalism, and the early decisions of the United States Supreme Court certainly recognize the essential role of the states in our federal system of government. Justice White in the Justice Chase in the case of Texas versus White declared that the Constitution is all of its provisions looks to an indestructible union composed of indestructible states. Of course, the 10th Amendment, you know about that. I'd like for you to give us your general philosophy of the role of the judiciary and relative to federalism.
Well, I can give you my view of what it's been up to now, anyway, or at least in this century. The fact is, it seems to me, that the primary defender of the constitutional balance, the federal government versus the states, maybe versus isn't the way to put it, but the primary institution to strike the right balance is the Congress. It is a principle of the Constitution that there are certain responsibilities that belong to the state and some that belong to the federal government, but it's essentially the function of the Congress the Congress, which takes the same oath to uphold and defend the Constitution that I do as a judge, to have that constitutional prescription in mind when it enacts the laws. I think the history of this century, at least, shows that by and large, those congressional determinations will be respected by the courts.
Well, there are certain people of diverse ideologies that seem to embrace the concept of one federal legislative act as the cure for any major problem. These widely diverse groups, they are the extreme liberals and the extreme right-wingers, seem to at least agree on on the fact of trying to find a single cure for problems that they consider to be monumental problems. And, for example, the extreme right now seems to want a federal cure in the area of abortion, gun control, tort reform, labor violence. Does your belief in constitutional government include a belief that there should be a deference to the states in seeking solutions in areas that traditionally and historically have been considered to be in the jurisdiction of state government?
Certainly, as a member of the legislature, Senator, that would be my view. I think my writings show that I take seriously the one of the checks and balances, which are the ultimate protection of individual liberties in the Constitution. One of them is the fact that you have not just a unified centralized government, but also 50 independent states, and that the work of government is divided between those two entities. As to whether that question is of much relevance to me in the vast majority, if not all of the cases that I have to decide, that's quite a different issue. I think what I'm saying is that on the basis of the Court's past decisions at any rate, the main protection for that is in the policy-making area, is in the Congress. The Court's struggles to prescribe what is the proper role of the federal government vis-a-vis the state has essentially been abandoned for quite a while.
You don't care to comment on what you think from a position of being a member of the judiciary would be as opposed to the legislative, as you have stated?
I think that's right, Senator. I think what the Supreme Court decisions on the subject show is that it's very hard to find a distinct justiciable line between those matters that are appropriate for the states and those that are appropriate for the federal government. That finding that line is much easier for a legislator than for a court, and by and large the courts have not interfered. I expect there will be more arguments urging that they do so in the future, and I, of course, keep an open mind.
Let me ask you about the issue. You spent some time as head of the administrative conference, have written a good deal on administrative law and have taught administrative law.
Yeah.
We now have a situation where we have administrative law judges, and the administrative law judges outnumber the U.S. District Court judges and the Circuit Court of Appeal judges, I believe, more than 2 to 1, something like maybe in the neighborhood. These are ballpark approximate figures of about 1,400 administrative law judges as opposed to about 700 of the other type of judges.
Senator Heflin, if I might interrupt you, the time has expired. If you finish this question and proceed to the answer.
Well, there's been proposals to try to establish an independent corps of administrative law judges. Do you have any opinions relative to proposals to establish an independent corps of administrative law judges?
I wrote an article some years ago, Senator, in which I essentially supported the concept of a corps of administrative law judges, but the quid pro quo for establishing the corps, right now, of course, each agency has its own judges. The corps proposal is that there be a central depository of administrative law judges, an ALJ court, in effect, which would decide cases from all agencies with maybe specialized panels of that court. I wrote a piece that thought that concept was worth exploring, provided that what went along with it would be the understanding that all administrative law judges would not all be the same grade level as they now essentially are in each agency. And in most agencies, it's a very high level. It seemed to me in that article, at least, that what we should be moving for is a career administrative judiciary, which is what most other legal systems have, so that you could, many of the administrative matters that need to be decided do not take as experienced, as seasoned, as knowledgeable, as expert a judge as a major rate-making case, and it would make sense to have judges of varying degrees of experience and hence varying grade levels who can work their way up through the court and ultimately be assigned to the most difficult cases.
Judge Scalia, as I had suggested in the very brief opening statement, the questions that I have for you are really limited to certain of what I consider to be the rock bed propositions on the authority of the court to decide questions with finality on the interpretation of the Constitution coming from Marbury versus Madison, which you've already commented about a bit, and the issue of the court's authority or jurisdiction to make those decisions in the context of any effort by the Congress to circumvent the court's power, should the Congress seek to do so by trying to cut off jurisdiction, and then the issue of the incorporation doctrine. And that really amounts to the areas of concern which I have. Starting first with Marbury versus Madison, I believe you testified earlier that a decision as old as Marbury versus Madison 1803, which does establish the basic power of the Supreme Court to decide the final interpretation of the Constitution, is a settled issue as far as you're concerned?
I said, Senator, it's a pillar of our system. I don't want to say that anything is a settled issue as far as I'm concerned. If somebody wants to come in and challenge Marbury versus Madison, I'll listen to them. But it is obviously a pillar of our current system. Whether I would be likely to kick away Marbury versus Madison, given not only what I've just said, but also what I've said concerning my respect for the principle of stare decisis, I think you'll have to judge on the basis of my record as a judge in the Court of Appeals, and your judgment as to whether I am, I suppose, on that issue sufficiently intemperate or extreme. But I really don't want to say, with respect to any decision, that I would not listen to a litigant who wants to challenge it. I invite you and urge you to make your judgment. I think the question you're asking is quite a relevant question. I wouldn't want to confirm anybody that I believed would destroy certain decisions, but I think the way you have to come to that judgment is on the basis of my past record as a thoughtful, moderate lawyer and judge, and on the basis of my writings and my records in the past. I don't want to be in the position of saying as to any case that I would not overrule it.
Well, you just used a magic word, Judge Scalia, moderate. You consider yourself a moderate judge?
I suppose everybody considers himself a moderate, Senator. I do.
Well, I don't know about that.
Well, maybe everybody doesn't. I do, anyway.
Well, I think you've come pretty close to saying that you consider Marbury versus Madison an indispensable part of constitutional law in establishing the authority of the Supreme Court of the United States to interpret the Constitution, but you haven't quite said it. You said it's a pillar.
It's certainly an essential part of the system that we now have.
Well, I'll infer a yes from your answer, although you haven't directly said it. I think maybe I'd even say you've implied it, but let me move on to the issue of jurisdiction of the court, and I'm appreciative of the fact that that is an issue which could come before the court. I hope it doesn't. We have Ex parte McCardle and we have U.S. versus Klein, and I'm sure you're familiar with the line of questioning that I undertook with Justice Rehnquist on that subject. But it seems to me that where you have the issue of jurisdiction, if the Congress can legislate and say that the Supreme Court of the United States no longer has jurisdiction, for example, on First Amendment rights of speech, press, and religion, that the pillar of our system is gone and the court no longer has the authority to decide constitutional questions. So let me ask you the question that Justice Rehnquist did answer without making any binding promises, because we're not looking to that today. But would you think that the court would have to have the authority, even in the face of a congressional enactment trying to take away jurisdiction, to retain the power to decide the fundamental questions of First Amendment, speech, press, and religion?
Senator, I'm afraid I'm at the same place on that I was on Marbury versus Madison. In fact, I think ex parte McCardle was probably described too generously as being a decision of the Supreme Court that seemed to indicate, on the one hand, that the jurisdiction could be taken away entirely, and then United States versus Klein suggesting to the contrary. Ex parte McCardle actually didn't quite go even so far as to allow the jurisdiction to be taken away. It allowed the jurisdiction, habeas corpus jurisdiction, to be taken away under one statute, and the court went to some pains in the opinion to point out that this is not to say that there is no habeas corpus relief at all. There is just no habeas corpus relief under the particular statute as to which Congress had withdrawn it. So I don't think that there's an opinion on the books that is even as possibly antagonistic to your view as ex parte McCardle has been described. I share your concern with the ability of Congress to simply remove jurisdiction entirely from the Supreme Court. It is obviously a jolt to the system, to put it mildly. I just don't want to be, and don't think I properly can be in the position of saying that I would rule unconstitutional any piece of legislation that does that. I think I must ask you to judge what I am likely to do on the basis of your estimation of my my legal views, my loyalty to the meaning of the Constitution as you understand it.
Well, would you say that the jurisdiction of the court on speech, press, and religion is a pillar of our system?
I think the jurisdiction of the court on any matter is obviously a pillar of the system that we have.
All right. Well, you're talking about pillars. You're putting it on the same level as Marbury versus Madison, so that is an advance. Judge Scalia, the problem that I find with the limitation as to what you're willing to testify about is that it doesn't give a commitment to certain very, very basic principles. And I haven't asked you to go very far, and I really wouldn't. And I don't think there's any doubt about your confirmation as we're sitting here at the moment. But there is a real problem institutionally as I see the attitude and the responses which you take, and I respect them. I respect them totally. But I'm not asking you what you're going to do with some of the really hot, controversial issues where people are hanging on bated breath as to where you stand, that you know are going to be coming up, and that if you answer one way, you're going to make one group of senators mad, and if you answer another way, you're going to make another group of senators mad. I'm going on Marbury versus Madison and jurisdiction of the court to real pillars that the building falls down. And the question I have for you is, how does a senator make a judgment on what a nominee for the Supreme Court is going to do if we don't get really categorical answers to fundamental questions like that?
I think it's very hard, Senator, when you're dealing with someone that doesn't have a track record, where you can't read that individual's opinions in the past, dealing with the important features of the Constitution and of statutes, seeing how that person deals with the materials, seeing that person's veneration for the important principles that you're concerned about. In my case, you have 4 years of that. You have extensive writings on administrative law and constitutional law from the years when I was a professor. You have testimony and statements that I made when I was in the executive branch. I am as sympathetic to your problem as you've said you are to mine. I think, at least in the present circumstances, as I see my responsibilities anyway, my problem with answering the easy question, Senator, is that what's an easy question for you may be a hard question for somebody else. And as I commented earlier, it's not a slippery slope, it's a precipice. Marbury versus Madison, we all agree about. Jurisdiction of the court, it goes from one to the next, and I'm very unable to say this is the line where it suddenly has become a doubtful question. That indeed is prejudicing future litigants who should be able to come up and argue that we have seen, Plessy versus Ferguson might have been considered a settled question at one time, but a litigant should have been able to come in and say it's wrong, and get a judge who had not committed himself to a committee as a condition of his confirmation to adhering to it. That's what I'm struggling with, and I hope you have enough material to judge my reasonableness and my fidelity to the Constitution to assure you that on matters that you consider rock bed and that are rock bed, I would not pull the structure down.
Well, suppose someone wanted to litigate, and let me give you an absurd proposition. Suppose someone wanted to litigate your responsibility under your oath to uphold the Constitution. Would you hear litigants on that question?
I will hear a litigant on, well, I will hear a litigant in my present court on any question, Senator, and I've heard some fairly far-out arguments. In the Supreme Court, I won't have to do that because we have some option as to whether we decide to take a case or not. But in theory, I think I have to make myself available to any argument.
Well, let me ask the absurd question one more step closer. If you're confirmed, will you take an oath to uphold the Constitution?
I certainly will.
Well, of course you will. Will you let somebody litigate after you're on the Supreme Court whether you have an obligation under your oath to uphold the Constitution?
I think you've finally gone over the edge of absurdity so much that I have to say, of course not.
Well, wonderful. And we've gotten the finale.
I'm on the precipice, you're telling me now.
No, that's a finite answer, and that's a conclusive answer, and that's a commitment. As I review the answers by Supreme Court justice nominees, there has been carved out a large range of exception where nominees simply do not answer questions. And I think that's justified in the highly controversial settings where it's imminent that that question is going to come up and there's a sharp difference of opinion on it, and maybe on more practical grounds where getting into those areas is going to place the nomination in jeopardy in terms of the confirmation process. But I believe very firmly that if you're talking about the issues we've discussed so far, Marbury versus Madison, the authority of the court, or the jurisdictional issue, that we really ought to be able to have those answered positively and in terms of commitment. But your failure to answer it is not going to cause me to vote against you.
Well, I hope not, but I don't want you to think less of me for failure to answer. I've thought about this issue a long time because the one thing you know is going to come up in every judicial confirmation hearing, in particular Supreme Court confirmation hearing, is this issue of what questions can you answer, and it is a constant problem. And I realize that some nominees have tried to answer some questions and not answered the other. I thought long and hard about that problem, and I came to this conclusion, that if indeed it is obvious, then you don't need an answer. because your judgment of my record and my reasonableness and my moderation will lead you to conclude, heck, it's so obvious anybody that we think is not a nutty would have to come out that way.
That standard.
If, on the other hand, it's not obvious, then I am really prejudicing future litigants. So taking all that balance into account, I just concluded that the only safe position that I can take in conscience is to simply not say that there's any particular case that I would absolutely vote against a litigant who urges a position that is contrary to it.
Well, the problem with that, Judge Scalia, is that if we take what is obvious, then we look at your record, we look at your writings, we don't need a hearing.
Well, no, no. I think you have to look at my writings and ask me about my writings and test those writings to see what I meant about some elements of them. I've been questioned about cases that I've written, and I'm happy to respond to answers about what they meant and why what I said in them or what I did in them is not bad. I've been very open on those and will continue to be. It's just predictions as to how I will vote in the future that I'm drawing the line at.
Well, let me ask you the questions about the incorporation doctrine, because I want to put those on the record. Would you say that the issue of the due process clause of the 14th Amendment having incorporated the Fifth Amendment privilege against double jeopardy is settled as the case was decided in 1969 under Benton versus Maryland?
Yes, I will say that that's an accepted part of current law.
And would you say that the self-incrimination and just compensation clauses decided in Malloy versus Hogan and Chicago B&O Railroad versus City of Chicago are a settled matter of constitutional law?
They certainly have been clearly settled by the Supreme Court.
And would you say the same thing as to the incorporation clauses of assembly and petition, press, speech, and religion, that the 14th Amendment due process clause incorporates them?
Indeed. It would be quite a jolt to the existing system to suddenly discover that those series of protections against state actions do not exist.
And Sixth Amendment, speedy trial, public trial, and jury trial, all incorporated by the due process clause?
Indeed.
And impartial trial, notices of charges, confrontation, compulsory process, right to counsel, still in the Sixth Amendment, are all incorporated by the due process clause of the 14th Amendment?
That's what the cases have held, and it would be a massive change to go back on them.
And similarly, with the cruel and unusual punishment clause of the Eighth Amendment incorporated by the due process clause of the 14th Amendment?
Same answer, sir.
Would you say that those would come into the categories of pillars of constitutional law?
Marbury versus Madison is a pillar. If that's a pillar, I don't know what. I would just say it's a very accepted and settled part of our current system, and it would be an enormous change to go back.
Thank you, Judge Scalia. Senator Metzenbaum.
Mr. Chairman.
Senator Simon.
Maybe Senator Metzenbaum.
Senator Metzenbaum has not had a round yet.
Pardon?
Senator Metzenbaum has not had his first round.
I apologize. I thought he had his question. Sorry.
Judge Scalia, in an article, I'd say parenthetically, you've been very patient. It must be a long day, and you must be a bit weary, and your family must be wearier. But I'm glad the younger portions went home. In an article entitled "The Judges Are Coming," you made this statement: "It would seem to be a contradiction in terms to suggest that a state practice engaged in and widely regarded as legitimate from the early days of the Republic down to the present time is unconstitutional. I do not care how analytically consistent with analogous precedents such a holding might be, nor how socially desirable in the judge's view. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong." The problem I have with that statement is that the Supreme Court throughout our history has had the responsibility to declare that certain widely accepted practices violate the Constitution. For example, deciding that segregated schools were unconstitutional and that legislative districts had to be apportioned fairly. Are you saying that as a Supreme Court justice, you would oppose decisions which prohibited widely accepted practices? Or stated another way, does that mean that if a Gallup poll says 80% of the people have a particular point of view, then court decisions to the contrary, in your opinion, those decisions are quite simply wrong?
Can I talk about what I meant when I wrote that article instead of putting it in the context of what I would do?
No, I'm asking that.
Yes,
I'm not asking what you would do.
Right. The point I was trying to make, Senator, was simply this: there is an ongoing debate it's always been ongoing, but it's just more publicly known now about strict constructionism versus a more evolutionary theory of the Constitution. And I am speaking particularly about decisions of the court that give content to provisions of the Constitution that are not sufficiently explicit to strike down particular practices. If a practice that constitutes plainly racial discrimination existed in all the states, it would make no difference whether it existed from the beginning of the 14th Amendment down to the present. If it's facially contrary to the language, obviously there's no problem. And that's not the situation I was referring to. I was referring to the situation where a court is giving content to, in particular, the due process clause of the 14th Amendment, what particular substantive protections that might incorporate. And what I felt, and it was the point of that article, was that the judges have authority to give such content, no doubt, but I do not know how a judge intuits that a particular practice is contrary to our most fundamental beliefs, to the most fundamental beliefs of our society, when it is one that was in existence when the constitutional provision in question was adopted and is still in existence. Now, when I say a practice is in existence, I'm not referring to a Gallup poll. I'm referring to the understandings of the people reflected in the legislation that their representatives have adopted. I would find it very difficult, I was saying in that article, to strike down a provision on the basis of substantive due process in particular, where it's a provision that state legislatures generally adopted at the time the 14th Amendment was passed and continue to generally adopt. When one leaves that point of departure, you're left to the individual preferences of the judges, and I am not comfortable with imposing my moral views on the society. I need something to look to, and what I look to is the understanding of the people. The strict constructionist would say use only the understanding at the time of the 14th Amendment. The evolutionist would say no, the understanding today as well. Whichever of those two you use, and as I said in some earlier questioning, I'm a little wishy-washy on that point, but whichever of the two you use, it seems to me that either one or the other has to reflect the new right that you found. If it was neither there when the 14th Amendment was adopted nor is there today, then it seems to me, I was saying in that article, I'm making it up.
Well, it seems that you're equivalent of saying the Constitution means what the majority says it means. I have difficulty with this whole majority approach. And in your language is very clear. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong.
Well,
that's a very bold statement. Maybe bold is even a mild word.
Well, maybe I shouldn't take it on frontally, but let me do it. I would even, it is true in a way, it seems to me, that a Constitution has to have ultimately majoritarian underpinnings. To be sure, a Constitution is a document that protects against future democratic excesses, but when it's adopted, it is adopted by democratic process. That is what legitimates it. And the point I was making in that article is if the majority that adopted it did not believe this unspecified right, which is not reflected clearly in the language, if their laws at the time do not reflect that that right existed, nor do the laws at the present date reflect that the society believes that right exists, I worry about my deciding that it exists. I worry that I am not reflecting the most fundamental, deeply felt beliefs of our society, which is what a Constitution means, but rather I'm reflecting the most deeply felt beliefs of Scalia, which is not what I want to impose
Judge,
on the society.
The real problem I have with your article and your own statements today relates to the fact, and I'm sure you remember it, that when the Kefauver Committee was active, I wasn't here in this body, but I remember there was a great hue and cry to repeal the Fifth Amendment. Anybody taking the Fifth was per se practically bad person. We ought to repeal the amendment, that'll solve it so they can't take the Fifth. And then I have a recollection of somebody's poll, and I don't know whose, whether it was Gallup or somebody else, checking with people as to their views on each of the separate constitutional amendments to the Bill of Rights. And overwhelmingly, American people indicated they don't support that concept. Now, I sit here concerned, is this new Justice of the Supreme Court going to start to find ways to change that Bill of Rights? Because it is a fact. It is tougher. It is one of the toughest things that some of us have, and that is to stand up for an unpopular point of view on the basis that that's a person's constitutional right. It's sometimes, I guess I remember one case, the case up there in Illinois where the Nazis were picketing or they were marching, and the Jewish community came out en masse to try to stop them from doing it. And I remember the American Civil Liberties Union got into great trouble because
Skokie, as I recall.
Pardon?
Skokie.
Skokie, that's right. And in that case, the American Civil Liberties Union lost a lot of its members, but they stood up for what they thought were their constitutional rights, even though they'd be unpopular. I'm worried about you're going on the court and reacting. What's that? Let me just. 15-minute roll call. I guess they reform Republican senators as well as Democrats. I think I may have cut you off. Had you finished?
No, you just made a statement that I don't disagree with your concern. All I can say to it is that the views I expressed certainly do not reflect the notion that I will be swayed by Gallup polls or by current public opinion. To the contrary, if there is an established constitutional right that has been set forth in the Constitution, and that or even if not set forth very explicitly, is clearly established by the practices of the society, I would assuredly not allow the mere fact that the current society, inflamed by one passion, prejudice, or another, wants to stomp it out. I would not allow that to affect my judgment. Quite to the contrary.
Let me ask you a little bit.
I don't mind taking unpopular positions, Senator.
Let me ask you a personal matter about your membership in the Cosmos Club. I think you were a member.
Yes, sir.
You a member from 1971 to December 85. I think the Cosmos Club excludes women from its membership, and I think the ABA's position is that the membership of a judge in an organization which practices discrimination may give rise to perceptions by minorities, women, and others that a judge is not impartial towards minority groups. And then the ABA Standing Committee on Ethics and Professional Responsibilities has been considering the impact on the judiciary of judges who belong to discriminatory clubs. And the Judicial Conference in 1981 adopted a resolution that it is inappropriate for a judge to hold membership in any organization that practices invidious discrimination. And then in '83, the ABA Ethics Committee submitted to the House of Delegates proposed amendments on the membership of judges in private discriminatory clubs. More than half the population is female. And the women of the country have some concern, rightful concern, about a jurist who undoubtedly knew about some of these provisions of the ABA and the Judicial Conference. Do you want to comment on that?
Well, I certainly agree, Senator, that a judge shouldn't be a member of a club that practices invidious discrimination. I think the issue is whether that was invidious discrimination or not. I certainly would not belong to a club that practiced racial discrimination, because I don't think there's any basis for socialization on the basis of race, that there's any difference in company on the basis of the color of a person's skin or ethnic background.
Did you know Cosmos Club discriminated against women? Didn't have any women members?
I knew that it was a men's club, and what I was going to go on to say is that I don't consider that an invidious discrimination. I think there are a lot of other people who likewise do not consider it invidious discrimination. I realize there are those that disagree, that do not like organizations like the Knights of Columbus, or for that matter the Boy Scouts, and think that that should not be an all-male organization. I happened not to have felt that way, and thus was a member of the Cosmos Club. When I first joined it, Senator, was when I first came up to Washington to work in the executive branch. I lived in the club for about 6 months while my family was still in Charlottesville. One of the facilities of living there was that it was a men's club. Now, I understand there are people who feel differently about it. I am sensitive to their views. Towards the end of the period that I was membership of the club, that I was a member in the club, I was especially uncomfortable because I know that some of the judges on my court took the opposite view of whether there should be clubs of that sort. I happen to disagree. I'm no longer a member. That's all I can say.
I note you used a rather interesting story to illustrate one of your objections of affirmative action, and that's the story of Tonto and the Lone Ranger, and in it I think you have tell the story with the Indian dialect of English. I won't read the whole story, but it's a cute story, but the English dialect of the Indian I'm not quite so sure about. Everyone who knows you says that you are quite adept with the English language. The fact that you have exceptional verbal talent. How do you think the Indians of this country might feel about your reciting that story with some of the quotes?
Would you read the quote where I used
Yes. When John Minor Wisdom speaks of restorative justice, I'm reminded of the story about the Lone Ranger and his faithful Indian companion Tonto. If you recall the famous radio serial, you know that Tonto never said much, but what he did say was, disguised beneath a Hollywood Indian dialect, wisdom of an absolutely Solomonic caliber. On one occasion, it seems that the Lone Ranger was galloping along with Tonto heading eastward when they saw coming towards them a large band of Mohawk Indians in full war dress. The Lone Ranger reins in his horse, turns to Tonto and asks, "Tonto, what should we do?" Tonto says, "Ugh, ride 'em west." So when they wheel around and gallop off to the west, suddenly they encounter a large band of Sioux heading straight toward them. The Lone Ranger asks Tonto, "What should we do?" Tonto says, "Ugh, ride 'em north." So they turn around and ride north, and sure enough, there's a whole tribe of Iroquois headed straight toward them. The ranger says, "Tonto, what should we do?" And Tonto says, "Ugh, ride 'em south," which they do until they see a warpath of Apaches coming right for them. The Lone Ranger asks Tonto, "What should we do?" Tonto says, "Ugh, what do you mean, we, white man?" It's a rather cute story, but I think the use by you of a sort of a Indian dialect, I wonder if the Indians would feel offended by it.
I'm fully aware of that sensitivity, Senator, which is why, when I began the story, I made it clear that Tonto's wisdom was always Solomonic, but it was disguised between what I referred to there as a Hollywood Indian dialect. That is a disparaging term. I'm fully aware that Indians don't talk that way. It's how Hollywood portrayed them. I thought I made it very clear in what I wrote, that Indians don't talk that way, but that's the way Hollywood wrongfully portrays them. Now, if that is not enough of a disclaimer and the story has to be stricken from everyone's repertoire, I think that would be a great loss. And it doesn't work in non-Hollywood Indian. It really doesn't.
There's now a pending request for certain memoranda that we have worked out in connection with Justice Rehnquist. He waived any objection to our having that information. Do you have any objection to our obtaining information from the Justice Department concerning your efforts while you were there?
Personally, Senator, I have no personal objection to it. There's nothing I did at the Justice Department that was other than honorable. I'd be less than honest if I didn't say that having worked in the Office of Legal Counsel and defended its prerogatives for 3.5 years or so, I'm concerned about the institution, about the effect that such probing, or more specifically the awareness of the fact that whatever the head of the Office of Legal Counsel writes will henceforth, should he ever be subjected to questioning in connection with a confirmation, which is very likely because most heads of the Office of Legal Counsel, or many of them at least, go on to later government positions. I think it would be harmful to the office if it is known that everything he puts down on paper by way of advice to the Attorney General or to the agencies will be made public. I fear that it may make his advice less frank, less forthright than it otherwise would be. That's purely an institutional objection. It's up to the President to defend that institution. Personally, I'm not ashamed of anything I did while I was there.
And you have no personal objection?
I have no personal objection, Senator.
I have no further questions.
Thank you. Take a recess, and the first, after the recess, James Senator from Illinois.
I thank you, Mr. Chairman.
We'll take a recess now and go and vote.
Stands for. Let me first throw you a softball question. You will be one of the leaders of the law in this nation. You have been a law professor at Stanford and University of Chicago, University of Virginia, I believe. We, in 1970, had 270,000 lawyers. We now have 640,000, graduating about 39,000 a year. There are those who believe the numbers are so high that it can present problems in our society. Do you have any reflections on this? And if so, if there is a problem, what we do about it?
I share the perception that there is a problem, Senator. I'm not entirely sure what to do about it. To some extent, the problem feeds on itself, of course. The story of the fellow sitting in a train, and the gentleman next to him asked him what he does, and he says, "I'm a lawyer." And the fellow says, "Gee, what do you know that? We used to have a lawyer in my hometown. Poor devil, he could hardly make a living. Then another lawyer moved in. Now they're both doing fine." To some extent, the very increase in the number of lawyers creates yet greater litigiousness. I don't know whether it's, it does seem to be a trend that is beginning to slow down a little bit. The answers that are being sought are alternative dispute resolution mechanisms other than the courts, and my understanding is that there is some success with those mechanisms. Unfortunately, the resort to those mechanisms is in itself something of an admission of failure. People want to resort to them because the courts are too crowded, it takes too long to get justice there, and it's too expensive, which is a sad commentary. I'm afraid I just don't have an answer. I share your perception of the problem.
It was not a question you expected to be asked during this hearing, I have an idea.
I didn't.
Let me read from a staff memorandum along with your opinion. It draws this conclusion. It says, "From these and the other cases included in this book, it is easy to see where Scalia's sympathies lie. He will interpret civil rights statutes narrowly. In cases of race discrimination, a plaintiff will have a very difficult time proving his case because of the high standards Scalia imposes on race cases. The same will be true with gender discrimination. To be sure, the court will have an ardent enemy of affirmative action in Scalia, and in future cases, he can be expected to leave his mark." In his article, quoting from an article of Washington University Law Quarterly, you say, "Justice Powell's opinion on affirmative action, which we must work with as the law of the land, strikes me as an excellent compromise between two committees of the American Bar Association on some insignificant legislative proposal. But it is thoroughly unconvincing as an honest, hard-minded, reasoned analysis of an important provision of the Constitution." Do you have any comments on my staff's conclusion looking at that area of your decisions, and any reflections on your Washington University article?
Well, we discussed that article a little earlier, and as I said there, it was addressing mainly the policy of affirmative action, not its constitutionality, whether it was desirable. That is, of course, a disagreement concerning the means to the end. I don't think, I hope there's no doubt about my commitment to, or there should be no doubt about my commitment to a society without discrimination. If the notion there is that I'm hostile to laws that seek to eliminate that, that's simply not true. I'm in a way having any animosity towards racial minorities. In my case, would be a form of self-hate. I'm a member of a racial minority myself. Suffered, I expect, some minor discrimination in my years, nothing compared to what other racial groups have suffered, but it doesn't take a whole lot to make you know that it's bad stuff. My wife's mother remembers the days, she's a Fitzgerald from Boston. I wish Senator Kennedy were here to know that. But she remembers the days when there were signs in Boston that said, "No Irish need apply." I find all of that terribly offensive. I'm a product of the melting pot in New York, grew up with people of all religious and ethnic backgrounds. When I lived in your state, Senator, I didn't live in a monochrome suburb, but I lived in Hyde Park, and my kids went to school, a school that was at least 40%, maybe more than that, black, not white. My kids socialized with and dated people of all races. I have absolutely no racial prejudices, and am, I think, probably at least as antagonistic as the average American, and probably much more so towards racial discrimination. Beyond that, I can just say that I disagreed with affirmative action in that article as the way to eliminate it, because side effects that I saw that could be worse than what was than what the particular affirmative action program would eliminate. In any case, those policy views will not inform my decisions on the Supreme Court, as I do not think they have informed my opinions on the Court of Appeals. I think it would be a different matter if those opinions showed any racial hostility or hostility towards the laws, and I don't think they do.
Let me phrase the question a little differently. Let's use an imaginary scene at the White House that might have taken place. The President asked the Attorney General, get me the 6 best names you can get in the nation. And he comes up with 6 names. One is named Jones, one Smith, and he looks through, and one is named Scalia. And the President says, it'd be a good thing to have an Italian American on the Supreme Court. 6 outstanding nominees, and it is not difficult in this great land to find 6 outstanding nominees. Is there anything fundamentally wrong with the President making a decision on that kind of a basis, in part, assuming you have 6 quality people there?
Fundamentally wrong you mean on illegal or morally wrong?
Well, from the viewpoint of the theory of government.
No, I think that it's a good thing. Certainly in my own hiring practices, I've tried to have a mix of people among my law clerks and elsewhere. No, I can't say that's
okay. And so, if Congress, through the if we decide that affirmative action, if we see a plant where there are 2,000 whites and no blacks, we say, as you award contracts in the defense area, let's try and encourage employers to follow practices that give opportunities for people. We're not saying you should hire people who are not qualified, but let's have a society where there are opportunities for everyone. If Congress passes laws requiring that, and I don't want to get into, we're getting close to territory that you may feel uncomfortable responding on, but just in the abstract, do you find that offensive from a legal point of view?
I don't want to. In the days when I wrote that article, I actually gave that speech, which became an article in the Washington University Law Review. I had policy views. I've tried not to have them, not have any public ones anyway, since I've been a judge. So I'd like not to comment on it as a policy matter. I just want to note that there is a difference between the first hypothetical you gave me and that. That is, and the difference is this: it's the president saying, it seems to me it'd be good to hire Puerto Rican or whatever, as his own voluntary decision, and on the other hand, saying the president or anybody must hire an Italian or a Puerto Rican or a certain percentage of them. The difference is that when you adopt the latter situation, you are automatically excluding some people from consideration. Now that makes a difference just as a policy matter. So it's a slightly different question. I guess that what my Washington University piece would say is that in the days when I had policy views, I didn't think it was a good idea. That has nothing to do with whether I would enforce it vigorously if it's passed by Congress.
I guess my experience is through life, and maybe yours too, that if you have policy views, inevitably they creep up or creep out or appear when you are on the Supreme Court or in any other position. But I guess what you're telling me is that is a policy matter for us to decide here in Congress, and you do not, and again in the abstract, you don't see a constitutional prohibition to Congress moving ahead.
Well, I guess we can get into the question whether the latter is a pillar or not, but I would like not to express a view on constitutionality of the matter. But certainly the policy of the matter is entirely Congress's. I am certainly in sympathy with the objective of Congress. Whether I am in sympathy with the particular means Congress has pursued to that objective, I assure you will have nothing to do with my decision in the case. I understand that it's hard, but it's a discipline that a good judge has, and I think it's one that I have.
Let me shift to another area. After looking at your decisions in the First Amendment area, this conclusion is drawn here. In all three of the important libel cases that have come before him, Judge Scalia has ruled against the press. I received a memo from my colleague, Senator Dodd of Connecticut, expressing some concerns in this area. Now, you have, in part, answered this question to one of my colleagues, but any kind of generalities you would like to make in response to this characterization of your stands?
I'd be happy to talk about the three cases, if you'd like. What three was it referring to? Do you?
Referring to the one was the mobile Pabula Rios, if I'm pronouncing it correctly.
Well, that was not. That is the one case one of very few cases I can't talk about because it's still before our court on petition for rehearing. But I can at least note that it was not my opinion. It was the opinion of Judge McKinnon in which I joined. Now, the holding of the case was on a factual matter. I think I'd better not try to defend the holding at all, except to note that the opinion was not mine. It was an opinion in which I joined.
But that characterization of your decisions, you believe, is not an accurate characterization.
I think sometimes you win, sometimes you lose. The fact that I've ruled or joined an opinion against the press doesn't prove anything. What are the other opinions, Senator? I think I can probably guess them.
The other one that's quoted here quite a bit is the Ullman versus...
Evans and Novak versus Ullman. Senator Hatch said a few words about that case earlier. It really is, as I think he pointed out, a sort of damned if you do, damned if you don't situation. I could have been criticized as being against Marxists had I come out the other way. It was a suit by a Marxist against a conservative columnist. The fact is that my dissent in that case, it's a dissent that they're referring to, was joined in by, if I recollect correctly, Chief Judge Robinson. The position that I took was joined in by Judge Robinson, Judge Wright, Judge Edwards, and Judge Wall. My opinion itself was joined in by Judge Edwards and Judge Wall. I don't think that that's any indication of a bias against the First Amendment, unless all of those judges are deemed to have the same bias, which I would doubt. The specific issue in the case was whether a particular it was a very narrow issue. We were all in agreement on the basic principles of First Amendment law, that it was libelous if it was not an opinion, it was not libelous if it was an opinion. And the issue before the court was whether the statement that this Marxist professor, who was up for appointment as chairman of the Department of Political Science at Maryland, University of Maryland, the statement that he had no status in his profession was not taken seriously by his colleagues, something to that effect, whether that was libelous. I thought that that was not a statement of opinion, but a statement of fact, that he was not highly regarded by his colleagues. And in fact, in traditional libel law, the classic libel is to say that you are not regarded as a competent by your professional associates. I just don't believe there's anything in there that's antagonistic to the First Amendment. I think the opinion that I wrote, which largely responded to Judge Bork's concurrence, had a statement which was quoted by a columnist to the effect that public figures getting a good amount of bumping from the press was fulsomely assured by New York Times versus Sullivan. It somehow came out in the press as though I was saying that the freedom of the press was fulsomely assured by New York Times versus Sullivan. I wasn't saying that at all. I was saying the fact that public figures will get a good amount of bumping was fulsomely assured, by which I mean assured not only sufficiently but more than sufficiently. I don't think that there's anything in that statement that demonstrates an antagonism towards the First Amendment. And the last case, Senator, was what? I'd welcome the opportunity to...
But I think you adequately covered it here. Let me shift to another area. You testified in 1981 on the tuition tax credit case, and you said in testimony, Senator Moynihan was taking the testimony, the court's decisions in this field set forth neither a settled nor a consistent nor even a rational line of authority that you could rely on even if you wanted to. You were not aware you were going to be a nominee for the Supreme Court when you said that. Do you have any general, well, the whole church-state issue, any reflections on that?
I suppose doesn't give any indication how I'm going to vote on any particular case. To say that I don't think that statement is would be much altered today, and I doubt whether there are very many people who would disagree with it, with the possible exception of, well, even the rational. The decisions are very difficult to reconcile with one another. The decisions that are on the books, the court, the rationale that's adopted in one case does not fit entirely well with the cases that have been decided in the past. I think that's common ground among people who discuss the Establishment Clause cases, whether the cases are thought of as being right or wrong. I think there is general agreement that it's one of the messiest areas of constitutional jurisprudence.
Well, assuming that, but do you have, are basic traditions pretty sound in this area, in the whole church-state area?
Basic traditions?
Yes.
I'm not sure what you mean by basic tradition, Senator.
Well, the constitutional principles as they have emerged over the past 2 centuries.
Well, I think what's sound is that what's accepted. The problem in the area, Senator, is a problem that largely arises because of a natural conflict between the Establishment Clause and the Freedom of Religion Clause. Both of those interests are very important. People ought to be able to practice their religion freely, and yet the government cannot establish religion. So you get cases like the case of the Jehovah's Witness, who wants to, being a Sabbatarian, wants to have Saturday off instead of Sunday, and wants to draw unemployment compensation when she's been offered a job that requires work on Saturday and turned it down. And the way the court resolved the case was to say it violated the Freedom of Religion Clause for a state not to allow her to draw unemployment compensation simply because she refused to accept a job that would require her to work on Saturday. Well, yes, that does protect freedom of religion, but on the other hand, doesn't that somehow amount to an establishment of religion, to have the state make a special rule to accommodate the religious belief of this Sabbatarian? That's the problem that runs throughout these cases, and that's the reason they are very hard to figure. On some occasions, the court seems to be giving more weight to the freedom of religion section of the First Amendment. On other occasions, it seems to be giving more weight to the Establishment Clause section. If I had to pick an area that, in the whole area of constitutional law that is in an unsettled state, I think that's the one, and I think many commentators would agree.
I see my time is up, Mr. Chairman. Thank you.
Senator Illinois from Illinois is correct, and the second round will involve, according to previous announcement of Senator Thurman, 10 minutes each, and the senator from Delaware is next.
I'm call
sorry.
home, Justice
You want me to-
Scalia. That's the call. I'm sorry. I thought we were going to yield to my colleague. I appreciate that. I'll yield to my colleague from Alabama, and then maybe I could ask my question.
The senior senator from Alabama.
Thank you.
You've been previously asked about the Inner Circuit Tribunal. However, question is phrased as to whether or not the appointing power ought to be the Chief Justice or the President. Under the proposed legislation, it's a temporary court of existing officers of the United States who have already been confirmed under the Constitution. The selection of those judges has been debated. There seems to be two alternatives, one being it'd be three alternatives, one being the Chief Justice appointing them, the others being the circuit themselves selecting their judge, and the third being the Supreme Court instead of the Chief Justice, all 9 members of the Supreme Court doing the selecting. Do you have any opinion on which you consider the better method of those three?
It sounds like the least of the evils offered, Senator, doesn't it? There are problems with all of them. It's very hard to envision.
Excuse me, Judge Scalia, if you could pull your microphone a little closer.
It's very hard to envision a court getting together for such a purpose to select one of its number to be the designee, or for the Supreme Court to select particular individual judges. It amounts to a kind of designation of ability and of primacy that I certainly wouldn't want to do it as a member of a court of appeals. I wouldn't particularly want to do it as a member of the Supreme Court either. Your judgment on that is as good as mine, Senator. I'd guess that having the Chief Justice do it is the least evil, but there are problems with that too. It doesn't give you the spectrum of opinion that having a body of people do it would.
All right, so...
Some questions don't have any good answers, Senator.
Well, sometimes can't get people to state a position. But let me ask you another matter. We've got an issue before Congress now on the impeachment of a federal judge. House's representatives has, in effect, brought articles of impeachment, which are in effect are an indictment. The Senate is supposed to sit as a trial judge. For the judiciary, this appears to be a rather cumbersome process. Some of the states have had other procedures for removal of judges, and I'm not trying to prejudge or do anything pertaining to the one before us, but I just wondered if you have any thoughts on any innovations or improvements that might occur pertaining to problems that could arise with judges in the federal branch.
Well, giving this answer now that I'm a judge does make it sound as though it's self-pleading, but I had the same view before I became a judge. It is a cumbersome process. I think it should be a cumbersome process. I think it's the major protection for the independence of the judiciary. The bases for impeachment are somewhat vague, and the bases that past Congresses have sought to use in most prominent cases are pretty vague. It seems to me that it is an important protection to the independence of a judge to be able to decide cases as he sees them, that removing them is a lot of trouble.
Well, some of the states have had various methods. Some have had the equivalent of a House action taken through a Judiciary Inquiry Commission, and then have a court of the judiciary, which is largely composed of judges and maybe also some lawyers. Others have had commissions which deal with the disciplinary and removal matter. You don't have any feelings about those, or you think the impeachment is more of a protection of independence than those methods?
I think much more so, Senator, and it's not as though the framers didn't know that they were establishing something that was very cumbersome and very difficult. They were out of step with many of the colonies at the time in what they provided for the judiciary. And one of the major debates at the convention was the provision on the judiciary, giving them life tenure, for example. Our federal judiciary is out of step with the states in many other respects. Many states have mandatory retirement age, as you know. Many states still, I believe, have election of judges. And all of those things were considered and rejected in favor of an extraordinarily strong, extraordinarily, more so than most of the colonies then and more so than most of the states now, an extraordinarily strong and independent federal judiciary. I think it was a conscious decision by the framers, and I happen to think it was a good one. I understand that it's, especially at a time when the Congress has plenty else to do, to have to sit in a trial of a judge is cumbersome.
I believe that's all the questions I have at this time, Mr. Chairman.
Senator from Delaware.
Thank you. You've had a long day, Mr. Justice, but from the time I've been here, it seems like you've had a pretty good day. And let me at least close out my questioning by asking for a couple clarifications and also to go into a little bit the privacy questions, Ninth Amendment. I understand in response to a question from Senator Metzenbaum, you indicated that you would not belong to a club that discriminated based on race, but you would not feel bound not to belong to a club that discriminated based on sex. Is that correct?
No, that isn't quite what I said, Senator. I said that I regarded the two as quite different, and that I would think that a club that discriminates on the basis of race or on the basis of religion would be invidious discrimination. I think the jury's out on whether it's invidious discrimination to have a men's club. That's what I said. I didn't say that
Try to hear the last part. The jury is out.
I think that there's room for disagreement on whether a social club that's a men's club or a woman's club is invidious to the other sex.
Could it be invidious if, in fact, the effect of keeping women out was to have a detrimental impact upon their ability to do business, or if they were businesswomen, or participate in sport, if they're sportswomen, or...
I can see that, Senator, yes.
Would you, where do you put the classification? I mean, in what context would you place those clubs which would discriminate based upon nationality?
Well, there's sort of a affirmative and negative discrimination, I suppose. There's certainly, I've been a member of Italian-American clubs that, members share a common heritage. The exclusion of others is not an invidious exclusion at all. And
if in fact,
likewise, religious clubs, I mean, they're, Knights of Columbus and whatnot. They exclude people of other religions, not invidiously, but just because they get together to celebrate what they have in common. I think that's the key to it, whether the exclusion is an invidious one or not.
if in fact there were a club or an organization that included not one group of people who shared anything in common other than the fact they didn't like the Irish or the Italians.
Yeah, I think that'd be invidious.
You've been questioned on this already, but in your, get to make sure I have the right title of the article, referred to as the Panhandle magazine article.
Yes, sir.
I understand that one of my colleagues quoted you, the provision that said, "I do not care how analytically consistent with analogous precedent such a holding might be, nor how socially desirable the judge's view, nor how socially desirable in the judge's view, if it contradicts a long and continued understanding of the society, as many of the Supreme Court recent constitutional decisions referred to earlier in fact do, it is quite simply wrong. There will be no relief from the most far-reaching intrusions of the modern judiciary until the Supreme Court returns to this essentially common law approach to constitutional interpretation." Now, as I understand it, if in fact it were a long-established societal view, it would... Why don't you explain it to me?
Let me try, Senator. I am deeply mistrustful of my ability, without any guidance other than my own intuition, to say what are the deepest and most profound beliefs of our society. And that's what it means to say that something is constitutionally required. It is in accordance with the deepest and most profound beliefs of our society. I find it difficult to come to the conclusion that something qualifies for that description when neither at the time the constitutional provision in question was enacted was it in fact the practice of the society as demonstrated by the laws that the society enacted, nor at the present time is it that way. Now, I can understand, and you get into the debate between the evolutionists and the original meaning types when you say, well, what if everybody now thinks it's awful and there are no laws on the books of this sort today, but there were in 1789, so it must be constitutional. It seems to me that's a good debate. But I find it very difficult to say that it's contrary to our most fundamental beliefs when both in 1789 and today, all of the states have, permit the practice in question, whatever it may be. Once you don't give me that to hang on to, Senator, I worry that I'm left with nothing to tell me what are our most profound beliefs except my own little voice inside, and I do not want to govern the society on the basis of that.
Well, let's talk about the Ninth Amendment in that context. The decisions, and I don't expect you to comment on how you would rule, But the decisions that have arisen, that have been somewhat controversial, where the right of privacy is asserted as being a right that is protected or recognized under the Ninth Amendment. I guess maybe that's the place to start, the Ninth Amendment. You believe that the Ninth Amendment, in fact, implicit in the Ninth Amendment, is a recognition of a right called the right of privacy, not to what extent it applies, but that there is such a thing as the right to privacy.
I think that's in effect asking me to rule on cases. I can say the Supreme Court has held that there is such a thing as a right of privacy. They haven't tied it to the Ninth Amendment. As far as I know, there's no Supreme Court holding that rests any right exclusively on the Ninth Amendment. They mentioned the Ninth in a litany of amendments from which various penumbras emanate, and
do you believe
that
there is such a thing as a constitutional right to privacy? Not delineating whether, for example, the right to terminate a pregnancy relates to the right to privacy, or the right to engage in homosexual activities in your home is the right to privacy, or the right to use contraceptives in your home is right. But is, in a philosophic sense, is there such a thing as a constitutional protected right to privacy?
I don't think I can answer that, Senator, without violating the line I've tried to hold.
Judge, I don't know how you...
I can tell you that that's what certainly a number of Supreme Court opinions now say.
Well,
but there's somebody may come in and say, just as somebody might come in and say Marbury versus Madison was wrong, that it doesn't exist.
Sure, they're making it say
that it shouldn't exist. I do not want to be put in the position of having I'm sorry, I believe in a right of privacy because I told the committee in connection with its considering my nomination that I believe in it.
Well, the fact you believe in a right to privacy doesn't mean that that a case before you, in fact, rises to the level of being guaranteed that right. I mean, I think you're being a little bit disingenuous with me here. If in fact you conclude that there's an existing right to privacy, that in no way predisposes you to have to rule one way or another about whether or not a right is claimed as being qualified under such a right.
No, Senator, I beg to differ. There has been scholarly criticism of the whole notion of right to privacy.
Well, I agree.
And it's not at all inconceivable that criticism will be reflected in a brief before the Supreme Court. And
that very well may be, but it doesn't. In other words, if the right to privacy exists, if you believe the right to privacy exists, and I believe you have stated in what was that in the CNN VK? Excuse me one moment. I believe, and I can't pin down where you said it. It was in an article.
I don't think you'll find
in the Panhandle article. Did you say that that the right to privacy is one of the deepest and most profoundly held beliefs in our society?
I don't recall having said that, Senator.
Oh, I see. Let me. I'm sorry, I misspoke. What was being referred to was your answer to me earlier, saying that in order to meet your test, it has to be one of the deepest and most profoundly held views in society. And you always, do you have any doubt the right to privacy is one of those deeply and profoundly held view of American society? Forget the Constitution. Let's just talk politics, you and me.
It's very hard to answer. You began this line of questioning by answering me, never mind what the right of privacy consists of. I can't answer that question without knowing what you mean by the right of privacy.
Sure, you can acknowledge whether or not you believe there is, in fact, let's start over again. Clean the slate. Do you believe that Americans as a whole believe that there is a right to privacy that they have, inherent, that they think they have a right to privacy? Do you think that's a deeply and profoundly held belief by American society? Whether it's found in the Constitution or found in natural law or found in their Bible or found in the Talmud, that's a society. I mean, do you have any doubt that Americans believe?
I'll give you that, Senator. I think
Good
that's
man,
right.
I tell you, we're getting there. All right. Now, having said that, do you believe that is there any doubt in your mind that the Ninth Amendment, in conjunction with other amendments as it relates to particular assertions of particular rights of privacy, if I can find the Ninth Amendment here so I don't misquote it. Do you have the Ninth Amendment sitting there? Dig it out for me, will you? Roman numerals confuse me, Judge.
Let's see if yours
Okay.
is the same as mine. I have one here, too.
All right. I almost read the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Is there any doubt in your mind that the people, at the time and now, believe they have retained the right to privacy, whatever that means?
No, I think there's no doubt in my mind of that.
Okay. Secondly, if in fact well, I don't have to go any further, actually. Because in fact, it seems to me if there, in some form or another, there is a constitutional protected right of privacy. What that means remains to be seen, whether it means the right to engage in homosexual activity in one's bedroom, or anything else remains. I'm not going to ask you to comment on that, but let me, and I guess my time, I know my time is up, but let me pursue this one step further, if I may. When I look at your musings on the, and I don't mean that in a derogatory way, because I love to read what you've written. I love the way you go about it. I mean, I wish I had you in class. I'm probably too old to have had you in class, but you're the kind of guy that I would have liked to have been in class. I could have gotten by with you because we could talk about philosophy. As long as you didn't ask me what the case stood for, I'd be all right. But when I tie your musings on original meaning and original intent, and where I must admit I put you more in the school of the original intent fellas than I do in the living Constitution area, I begin to be concerned about, and then when I take your second stated principle in the Panhandle article, which is basically that if it is a long-held societal view that has been, in effect, recognized through constitutional interpretation, case law, Supreme Court cases, then you would be very reluctant to overturn it. If I read that correctly, or am I putting words in your mouth?
No, yes, I think that's a fair statement.
Okay. Now, the irony of all ironies is that the people who are concerned about you, some who are concerned about you, women's groups are concerned, not all, pro-choice women's groups who are concerned about you, they are worried you'll use that rationale to overturn Roe v. Wade. That is that, we won't go through it all. Ironically, it seems to me you could read your view as saying, if that hangs in the law another 10 or 15 years, it'd be awful hard. You would, by your own test, have trouble overruling Roe v. Wade. So I guess what I'm asking, without asking about Roe v. Wade, is there a time frame? If it's on the law, on the books, if you will, if it's settled constitutional law for an extended period of time, and the argument to overturn that settled constitutional principle does not, in fact, meet the test of, on its face, being consistent with what the correct constitutional principle is, do you have to stick with what the settled law is? I know that sounds good, but you're making it understandably hard for me because we can't talk about specific cases.
I agree with the statement that long-standing cases are more difficult to overrule than recent cases.
What do you have to find as a matter of constitutional principle to overrule long-standing cases? And I'm not talking about any one case now. Constitutional principles enshrined, it's been there, reaffirmed by cases for 20, 25 years. What do you have to find as a logic to overturn it?
Well, in every case, Senator, you have to find that it's simply wrong, that it's not a correct interpretation of the Constitution.
Okay, that's what we're getting at.
You begin with that.
But how do you...
But as I've said, some cases that are so old, even if you waved in my face a document proving that they were wrong when decided in 1803, I think you'd have to say, sorry, too late.
1969.
Well, that's not 1803. All
I really
can
am
say
trying
is
to
that
get a sense of
time
the
is certainly
frame.
one of those.
What, when is the wine age?
It's not just I don't want to mislead you into thinking it's just a function of time.
No, I don't read it as just a function. As I understand it, if in fact enough time has passed, and notwithstanding the fact you could argue that it was wrongly decided at the time because it was a overgenerous interpretation of a right recognized but expanded, that if it becomes settled practice, and the argument to overturn it is not that it was an incorrect decision 25 years ago, but that because it was too expansive, but is the argument required to overturn it that clearly on its face they disregarded what was the clear intention of the Constitution? Case in point, Plessy versus Ferguson. That was on the books long.
Can I interrupt the senator from Delaware? He asked the question, when is the wine aged?
Well, I understand.
I would say the wine's time has come.
I understand that, but I appreciate his biting humor. But I thought this was a serious line of questioning. I'll cease and let my...
Well, it's not a question of cutting you off. It's a question
fine.
that the senator from Illinois has been waiting and...
Senator from Illinois just asked questions. If he can ask them again, I have no further questions. Thank you very much.
I thank you, Mr. Chairman, if I'm being recognized. You may, after this most recent dialogue, you may wish to decline to answer this next question on your constitutional right of privacy here, Judge. But following a question that Senator Biden and Senator Metzenbaum, may I ask why you resigned from the Cosmos Club?
The basic reason I resigned, Senator, I think I described earlier how I had first become a member. I used the club a lot. I lived there for 6 months. I used it a lot when I was in Chicago, because when I came up to Washington to testify or to do any other business, which I often did since ad law was my field, I would stay there. I came to use it very, very infrequently when I was a member of the court that I now sit on, which is at the other side of town. So I found I was having lunch there maybe twice a year, and I quickly calculated that it was costing me something like $250 a lunch, which didn't seem to me to be worth the trouble.
It's a pretty expensive lunch.
It is an expensive lunch.
But did you, in part, leave the club because you felt uncomfortable with the regulations of the club?
I would hesitate to say that, Senator. I don't know whether that alone would have done it. I told you that I was uncomfortable at doing something which, although I thought it was perfectly okay, was offensive to friends whose feelings I'm concerned about. But I can't say that alone was the reason.
One other question, and I will be very brief. You made a speech on legislative intent, which you say, among other things, if I were writing on a blank slate, I suppose I would call into question the fundamental premise upon which all use of legislative history is based. Then a little later on in the same speech, you say, as an intermediate federal judge, I can hardly ignore legislative history when I know it will be used by the Supreme Court. Now you will become part of the Supreme Court. Do you still believe if you were writing on a blank slate, you would call into question legislative history completely?
Sneaked in.
Yes, if I could create the world anew, I suppose I still would, but I will no more be able to create the world anew when I'm sitting on the Supreme Court than I could when I was sitting on the Court of Appeals, if I ever get to sit up there. And if the burden of your question is whether I would utterly ignore legislative history on the Supreme Court, the answer is no, I wouldn't.
I have no further questions, Mr. Chairman.
Senator Heflin, do you have a?
I only have one or two questions. Judge Scalia, I noticed you smoke a pipe. It may well be that someday you may have to rule on the right of privacy as to whether or not an individual can smoke a pipe in his study or in his bedroom. So I just, I hope that you take care of we smokers some of these days. No, I have no further questions.
I have just one or two questions, Judge. You have already testified concerning your approach to legislative history. What, in your judgment, as just as a general matter, what weight ought to be given to a committee report in identifying the intent of Congress in enacting a legislation in which the report accompanies? I think Senator Grassley asked you about a rather unusual situation, and might leave that aside, but just look at it as a general matter.
Senator, as a general matter, I am not as enamored of committee reports as authoritative expositors as some judges are. I may say, by the way, that my view on that matter is not idiosyncratic. There are, my impression is that a number of judges have come to feel that the process has gotten out of whack, that to some extent, because the courts have used committee reports to such a degree, the committee reports are no longer as accurate a device as they used to be. It's sort of the phenomenon of when the cameras go. It's sort of the phenomenon of you're never being able to look at yourself in the mirror and see what you really look like, because you know you're looking at yourself. And it's the same thing with committee reports. Once it was clear that the courts were going to use them all the time, they suddenly became a device not to inform the rest of the body as to what the intent of the bill was, but rather they became avowedly a device to make some legislative history and tell the courts how to hold this way or that way. Once that happens, they become less reliable as a real indication of what the whole body thought it was voting on. That's why I'm sorry if it doesn't please some of the senators, but I just have to say that I'm more suspicious of them than some judges may be.
I raise the matter not merely because of how it reflects on your views as a judge, but it also, I think, could be helpful to us in our committee practices. It's a matter of more than ordinary interest. A case decided by the Supreme Court this term, the Jingles case, Thornburg versus Jingles, turned in part on whether the report of this committee or some remarks on the floor better express the intent of Congress of the Voting Rights Amendments of 1982. And several members of the committee filed a brief, an amicus brief in the issue. Ultimately, the court agreed with us, stating that we have repeatedly recognized that the authoritative source for legislative intent lies in the committee reports of the bill. Now, I gather that you would feel there might be some circumstances in which that much recognition shouldn't be controlling.
I doubt very much, Senator, whether I would not use committee reports at all when I'm on the Supreme Court. But I do think that the view I'm expressing of greater skepticism than has been brought to bear upon them in the past is, unless I mistake my guess, the wave of the future. I think the courts sometimes are beginning to feel that they are being
Well, I hope the committee will listen to what you're saying, because I take that as a constructive criticism, and that we could do better on committee reports and be more helpful.
It isn't the quality of the report or the work that's gone into them, both of which are fine. The essential ingredient, however, is for the court to know that when the Senate voted on the bill, that's what the full Senate meant. And if there's some way that the actual attention of the whole body to that particular item, which very often is such a subsidiary item that one really has to wonder whether the notion that the full Senate had in mind this one statement in a multi-page report, whether that isn't utterly fictional. And if it is fictional, then it doesn't really represent the intent of the Senate when they voted.
I have to agree with you. It's a fairly rare event where the committee itself has any argument over the language of the report. And occasionally it happens where a line is written in or a line is stricken out, but that's, I think, the exception rather than the rule. Now, the subject of judicial activism is one that's important to the chairman. You published an article last year in which you noted the tendency to regard the courts as an alternate legislature whose charge differs from that of the ordinary legislature in the respect that while the latter may enact into law good ideas, the former may enact into law only unquestionably good ideas, which, since they are so unquestionably good, must be part of the Constitution. And you went on to say that every era raises its own particular threat to constitutional democracy, and the attitude of mind thus caricatured represents the distinctive threat of our time. I don't think anybody would disagree that unbridled judicial activism is a bad thing. Certainly Thomas Jefferson believed that. Did you mean to say that it is the distinctive threat of our times? Was a necessary resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put...
That you're right. That may have been too broad a statement. In the context in which I was speaking, it's the distinctive threat with relationship to the judicial process of our times. I think if there is one failing, and perhaps in our entire governmental process, bearing upon the relationship among the three branches.
And I would agree with the thrust of your remarks earlier today, in which you said that if legislatures were more precise, there wouldn't need to be so much judicial activism. In fact, we invited the one-man, one-vote cases, for example, came about as a result not of legislative imprecision, but rather legislative stalemate on the subject. And it represented a clear example of legislative failure which invited judicial activism, really demanded judicial activism. And in a case in which it apparently was a necessary resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put that characterization into context.
I'm sorry that article's gotten the most attention. It's doubtless the of all my articles, it's the one I'm least proud of. I'm not ashamed of it, but it was a couple of page thing in a rather popular as opposed to scholarly publication. Probably not even very popular, but at least not scholarly.
Well, I have just one more question, and that is on the question of original intent. Very popular subject for articles, lectures, speeches. What is your approach to this rather arcane subject?
Well, it's where I start from, Senator. I think the first step is to, and I use the term original meaning rather than original intent, which is maybe something of a quibble, but I think that one is bound by the meaning of the Constitution to the society to which it was promulgated, and if somebody should discover that the secret intent of the framers was quite different from what the words seemed to connote, it wouldn't make any difference. In any case, I start from the original meaning, and I think there's room for dispute as to what extent some of those elements of meaning are evolvable, such as the cruel and unusual punishment clause. The starting point, in any case, is the text of the document and what it meant to the society that adopted it. I think it's part of my whole philosophy, which is essentially a democratic philosophy, that even the Constitution is, at bottom, a democratic document. It was adopted by the people's acceptance of it, by their voting for it, and its legitimacy depends upon democratic adoption, either at the time it was enacted. Now, some of its provisions may have envisioned varying application with varying circumstances. That's a subject of some dispute and a point on which I'm quite wishy-washy. But I'm clear on the fact that the original meaning is the starting point and the beginning of wisdom.
Well, my time is up, but the chairman indulged me just to finish that question. What happens if the starting point is zero? For instance, the whole range of public school issues are beyond any scope of the founders' original intent because there wasn't a public school system. And so many of the public school questions that have come before the court couldn't have been precisely forecast by the founders, because you're talking about a whole institution that has been invented since their deaths.
On those types of issues, Senator, that where the law has to be applied to circumstances that just didn't exist at the time, you obviously have to decide as a judge what resolution would most comport with the application of that clause to the circumstances that did exist at the time. You try to make it fit.
Thank you very much, Judge Scalia. Thank you, Mr. Chairman.
Distinguished Senator Illinois.
I have no further questions. I would appreciate if we keep the record open, and if the Judge would not mind if any of my colleagues have any questions they want to submit in writing, that we include that in the record.
Thank you, Senator. Without objection, we'll do that. See, today is how long do you want to keep it open, Senator? Thursday?
If we could keep it open, but today is Tuesday. Yeah, how about keeping it open till Friday?
Friday?
Friday.
All right, your request, we'll do that. We'll keep the record open for any questions that any member of the committee wishes to propound to Judge Scalia until Friday. And Friday, say at 4 o'clock, would that be satisfactory?
Fair enough.
Any member who desires to submit questions by 4 o'clock Friday, it'll be agreeable. Judge Scalia, I want to commend you for the way you've handled yourself in this hearing. I think you're one of the best qualified men that's come before us to be a judge on Circuit Court or Supreme Court. Your successful law practice, professor of law in 4 different law schools, at least in 3, and then I believe you're a visiting professor at Stanford. And I've been impressed that you possess the qualities we need in a judge. An excellent judicial temperament and the other things I mentioned this morning. I think you will be able to assist the other judges on the court, too, in arriving at a consensus. I have a feeling that you're not only a good musician, but you're a persuasive talker. And with your great legal knowledge, I think you'll be able to help with a consensus. You have a reputation for being a hard worker, a man of great analytical skills, sound judgment, congenial personality. And all of these qualities, I think, will be of great benefit to you on the highest court in our land. The American Bar Association has found you well qualified. It's the highest rating they can give you. They'll be testifying tomorrow as the first witness tomorrow. But I just want to say to you that we are fortunate, I think, to have a man like you to be appointed to the Supreme Court, and I commend President Reagan for appointing you. And I wish you well on the bench, and I'm sure you'll have a successful tenure. And I don't think it'll be necessary now for you to come back anymore. If so, we will let you know. You're welcome to come back tomorrow. Some other witnesses, some for you and some against you if you want to be here, but it won't be necessary.
Thank you, Mr. Chairman. May I thank the committee for its courtesy, and I have genuinely enjoyed being here.
I have nothing.
Staying Senator from Illinois, do you have any comments?
I have nothing further, no.
Staying Senator from Maryland, do you have any comments?
Mr. Chairman, I join with you in congratulating Judge Scalia on a very fine performance before this committee. We've seen a good many judicial nominees who have come here, and I don't think any of them have surpassed Judge Scalia in the manner in which he has addressed the questions and the kind of thoughtful responses that he's given to the committee. And as I suggested a minute ago, some of his comments may be helpful to us in the conduct of our own business. So we appreciate your being here.
Senator.
We will begin at 10 o'clock tomorrow. And after we get through with the American Bar Association, we're going to allow 3 minutes to the other witnesses, and we want to finish this hearing tomorrow. We now stand in recess until 10 o'clock tomorrow.
I had to go to open up the Senate and has asked me to chair in his absence, and we'll proceed at this time. The current witnesses are representatives of the American Bar Association, Mr. Fisk, Mr. Lafitte, and Mr. Lane. And we will proceed at this time. And Mr. Fisk, if you will start.
Good morning, Senator Specter. My name is Robert B. Fisk, Jr. I practice law in New York City, and I'm chairman of the American Bar Association Standing Committee on the Federal Judiciary. With me today are two other members of our committee, John D. Lane of Washington, D.C., and Jean W. Lafitte of New Orleans, Louisiana. I should say that during the time that the investigation of Judge Scalia went forward, I was engaged in a major trial in New York, and I'm very grateful to Mr. Lafitte, who undertook to coordinate and chair the investigation that was conducted of both Justice Rehnquist and Judge Scalia. And of course, Mr. Lafitte did present the position of the committee to the Senate Judiciary Committee last week on Justice Rehnquist. Mr. Lane is the circuit member from the District of Columbia who conducted the principal part of the investigation on both Justice Rehnquist and Judge Scalia. We appear today to present the views of the American Bar Association on the nomination of the Honorable Antonin Scalia of Washington, D.C. to be an Associate Justice of the Supreme Court of the United States. At the request of the Attorney General, our committee investigated the professional competence, judicial temperament, and integrity of Judge Scalia. Our work included discussions with more than 340 persons, including the justices of the Supreme Court of the United States and many other federal and state judges across the country, a national cross-section of practicing lawyers, and a number of law school deans and faculty members, some of whom are specialists in constitutional law and scholars of the Supreme Court. In addition, we have had Judge Scalia's opinions reviewed by a team consisting of the dean and law professors from the University of Michigan Law School, by a separate team of practicing lawyers, and also by 3 students who were working in the office of one of our committee members during the summer. Finally, 2 members of our committee, Mr. Lafitte and Mr. Lane, interviewed Judge Scalia. Based on our investigation, the committee is unanimously of the opinion that Judge Scalia is entitled to the committee's highest evaluation of a nominee to the Supreme Court, well qualified. That evaluation is reserved for those who meet the highest standards of professional competence, judicial temperament, and integrity. Persons in this category must be among the best available for appointment to the Supreme Court. I filed with this committee yesterday a letter describing the results of our investigation and will not repeat those results in detail here, but I do request that the letter be included in the record of these hearings.
The letter will be made a part of the record without objection.
Thank you, Senator. To summarize our findings, Judge Scalia has an outstanding academic record and has demonstrated strong abilities in his service as a practicing lawyer, a teacher of law, and as an appellate judge. Our investigation has shown him to be extremely intelligent, analytical, thorough, hardworking, and devoted to the legal profession. His writing and analytical skills are widely acclaimed. The diversity of his experience as a practicing lawyer, as a law teacher in 4 of the outstanding law schools of this country, and as a federal appellate judge provide a valuable background for a justice of the Supreme Court. Notwithstanding isolated expressions of concern, our investigation revealed that Judge Scalia has an outstanding judicial temperament and that he is well suited for service on the Supreme Court from that standpoint. He enjoys the respect of his colleagues both on and off the bench for the soundness of his judgment and his congeniality. His integrity is above reproach. In conclusion, the committee, by unanimous vote, has found Judge Scalia to be well qualified to serve as an Associate Justice of the Supreme Court of the United States. Thank you very much.
Thank you, Mr. Fisk. I note from your report at page 3, you state that you interviewed a cross-section of the legal community, including women and minority lawyers. How many of the 340 persons interviewed came from the category which you label as, quote, women and minority lawyers?
I'm not sure I'm in a position to give you a precise number, Senator, and perhaps if you would like that, I will go back through the detailed interviews that we have. But the way this investigation.
I think the committee would be interested in the specifics, but can you give us an approximation at this time?
If I could say, Senator, just so you understand the way this process worked, and then I think I will be glad to answer the question. What we did right from the beginning was, as you know, we have a member in every judicial circuit and 2 in the Ninth Circuit. And what we asked each member to do was to go out in his or her circuit and conduct interviews with the federal circuit judges in that circuit, the Supreme Court, the judges of the highest court in the state courts, also leading lawyers, the presidents of the bar associations in the circuit, and also, of course, deans and members of the faculty of the leading law schools in the circuit. So we had a fairly standardized approach within each circuit, which each circuit member then implemented. And then what we have done in the letter is try to pull together the results of some 13 or separate investigations of that nature, and that's where we get the number that appears in this letter.
Well, I understand that, Mr. Fisk, but since there's been a question raised as to the issue of women or minority interest, that's why I'm directing the question specifically to get some idea for the committee as to how many or what proportion comprise the women and minority lawyers.
Well, again, I cannot give you a precise number because I haven't gone back.
I understand you can't give a precise number. Can you give an approximation?
Yes, but I would say more than 10%. But that is a rough judgment.
The report that you have submitted speaks very, very glowingly of Judge Scalia, and as does your summary here this morning. There is one comment at the bottom of page 3, quote, "There were isolated expressions of concern or objections about a lack of open-mindedness or the reasoning in his opinions." In order to give as full a picture as possible with any qualification being limited, as I read your report, to that single sentence, would you please expand upon that?
Yes.
And focus particularly upon, first, how isolated were the expressions of concern?
Well, first of all, Senator, as you probably noted, that sentence appears in the section of our letter that is headed Interviews with Lawyers. And this does refer to isolated expressions of concern that came from people within the group of about 80 lawyers that we interviewed. I would say, again, I would say it's a handful, probably not more than 5 at the most. And it came primarily from people who had argued cases before Judge Scalia who felt, I remember 1 or 2 comments to this effect, that during the argument they felt that he had a position that he was expressing through questions that he was asking, and these were people who had lost the case and who felt that perhaps he'd made up his mind and didn't really come with a full open-mindedness to the issue. I really should emphasize, though, that we used the word isolated very carefully. We searched for a word that we thought was appropriate to try to quantify that type of objection, and it really, I think isolated is the best word we could come up with, because overwhelmingly the sentiment of lawyers was to the contrary.
As to those isolated expressions, was their conclusion that Judge Scalia was qualified to be a Supreme Court justice nonetheless, or were their objections sufficiently strong, at least in their own minds, so that they opposed his confirmation?
I don't remember any lawyer that said he felt so strongly about it that he didn't think Justice Scalia should be on the Supreme Court.
Senator, if I may supplement Mr.
Yes, please do.
Remarks. I think there were a couple of lawyers who did indicate objection to the appointment based on, in one case I recall, judicial philosophy. another case because of prior opinions, without any explanation as to what in the prior opinions was the problem. But I do recall those in response to the Senator's question. I certainly share Mr. Fisk's comments concerning the isolated nature of these objections or concerns, though.
Going on to the top of the next page, where you have the category of interviews with deans and professors of law, you say, quote, again, there were isolated expressions of concern about his strong conservatism or lack of open-mindedness. Can you quantify there the number of those who expressed those concerns?
Again, I would say it's less than 5, Senator. It's out of 60. Out of the more than 60 that we interviewed, it's less than 5. Probably 2 or 3.
I think it would be helpful to the committee, Mr. Fisk, if you would be a little more specific on that. If you could give us precise numbers, I think there's some who would be interested in it. And as a matter of future report writing, at least speaking for myself, where you have some expression of concern, the more specific you can be, the more helpful it is.
Well, I'll try to get you the exact number, but I'm quite confident it's in the vicinity of 2 or 3.
As to those isolated expressions of concern, did any rise to the height of objecting to the confirmation of Judge Scalia?
Again, I don't recall anyone that would have opposed his confirmation on that basis.
So what you're saying is that on the total of these 340 persons interviewed, that although there were some isolated expressions of concern, that no one opposed his nomination to the Supreme Court?
Well, no, I would qualify that only to the extent that Mr. Lafitte did a moment ago, that there were perhaps two or three out of the 340 who felt that because of positions he had taken in some of his prior opinions or because of his judicial philosophy, he should not be appointed to the Supreme Court. But as you well know, our analysis does not really get into the question of judicial philosophy. But on the issues that we look at, integrity, professional competence, and temperament, I would say that there are, as I would say again, less than a handful of the 340 that would have opposed the confirmation.
Your analysis does not get into the issue of philosophy, but that is brought up by others on their own.
Yes, it quite often gratuitously volunteered.
All right, thank you very much, Mr. Fisk, Mr. Lafitte, Mr. Lane. Senator Heflin had arrived first, and I think the chairman had announced a policy of moving through the sequence and order of arrival by the senators, so we'll turn to Senator Heflin at this time.
I suppose Mr. Lafitte and Mr. Lane,
Who arrived second?
I'd like to know about your interview with Judge Scalia. How long did your interview last with him?
I think about an hour and a half, Senator.
What was the scope of your interview? What did you cover in your interview?
Well, we discussed some of his ways of proceeding on the court, that is, how he functions in the appellate court that he now serves, how he uses law clerks, how he writes opinions, that kind of thing. We discussed, actually the discussion, as is usually the case, was rather wide-ranging. We discussed something briefly about his personal life. We talked about, of course, the concerns that had been, that we had heard, and received his responses to those matters. I think we talked some about his early life. Those are the things that come to my mind, Senator Heflin. And as I say, this is usually the kind of discussion we have with a candidate for the federal judiciary.
Did you go off into issues, we'll say, like federalism or civil rights or women's rights, or did you discuss any of the, in effect, contemporary issues of the day, judicial issues?
Well, I certainly encourage Mr. Lane to amplify my remarks, but we did raise generally those issues because they had been suggested to us as matters that might affect his judicial temperament, because there had been expressions of concern about his open-mindedness with respect to such matters. So we talked in general terms about them.
Did you talk, like, say, covering the issue of freedom of press, some of his decisions and those type of issues?
I don't think we discussed them specifically.
Was
I think we raised the First Amendment cases as a matter of some concern that had been voiced, but just in general terms.
I was merely to add the fact that we did mention First Amendment concerns that have been raised with us. See, one of the purposes of this type of interview is to give the candidate an opportunity to explain to us his or her side of any issue that may come up in the course of the investigation.
Well, was he open, candid with you? Did he discuss these issues, go into it in some detail, explain his position?
To be, as best I can recall, none of this discussion was very lengthy. He was open. He was very relaxed and very friendly, and I think readily responded to any of the questions that we put to him.
Was he elusive or evasive on any
Not
of
at all,
Senator.
Not at all.
Did he attempt to, in an effect, in your discussions with him, decline to answer any questions on the basis of the fact that it might interfere with his future as a potential member of the Supreme Court, and that it might, his decisions, his discussion of the issues with you might in effect be considered as some sort of prejudging or prejudicing his mind or something to discuss it?
No, I think I'm trying to recall. I don't recall, Senator, questions that were so specific as to give rise to that kind of a problem in his mind. But he was very open with us and responsive to us as we talked about these concerns. And I think it's fair to say that his reaction was that, you know, one can always understand how there are people that will differ with one's decisions on issues of this kind, but that, in effect, he just does his best as a judge to come out where he thinks the law takes him.
Well, I think Judge Scalia, of course, from everything I know about him, is a very fine individual, fine jurist, a brilliant mind, everything else. But yesterday in our discussions and the various questions that were asked of him, I ended the day with some sort of a sense and feeling that he had been elusive, evasive, and had in an effect perhaps overly hidden behind some concepts of separation of powers, or on the fact that he might have prejudiced himself in answering questions. Now, I don't want to be unfair to him in any way, but I did come away with somewhat of a feeling that he didn't answer things that perhaps I thought that he should have answered, and that I didn't think that the potential position of being on the court necessitated his protective attitude over future writings or future decision making that he might have. Was there any of that relative to your discussions with him, or was he completely open?
Senator, I'll let Mr. Lane answer for himself, but I found him completely responsive. I do not recall any question that we asked him that he indicated he would rather not answer or that he thought he should not answer. I don't, and I certainly, my sense certainly was that he was completely open with us and forthright and very articulate in responding to our questions.
I think, so the record will be clear here, we did not try to press him on important issues of the day, and we did not try to find out how this man would vote on these important and difficult issues. I think we were sensitive to the problem, and I think we are also understand and sympathize with the problem you have in making your judgment in the process of confirmation. I think it's a difficult problem for the committee, and it's a difficult problem for the candidate. It's one that we really didn't try to press him in these areas, as the committee did yesterday.
Well, it is very difficult, and it's a task doing it that I couldn't help but on the basis